Good morning. We will convene our hearing for code enforcement here in St. Lucie County for March 4th, 2026. Let's pledge allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I have reviewed the minutes from our last meeting of February 4th, 2026, and I approve those minutes. Madam Secretary. At this point, Madam Secretary, please swear in the staff members.
Michael Jarahan.
Oscar Moreira,
Paula Guy, Melissa Brubaker,
Josh Navarro, Peter Avila,
Sandra Lenise, Miranda Morris.
Ryan Elvis.
do you affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Item 5 on the agenda, public comments. If anybody would like to comment at today's hearing on a matter that is not on the agenda, it's your opportunity to speak about anything in the county. You can do that right now. Seeing no one, we'll move on. We'll go to the consent agenda. There's only one item. It's a satisfaction of a fine and release of lien for 407 Engle Road, LLC. The case is 2304-110563. In reference to that case that I read into the record, I accept and adopt the consent agenda as submitted. Section 7, fine hearings. During this portion of our meeting, we will consider whether or not to levy fines against violators. And I say violators, not alleged violators, because anybody who appears in this section has already deemed to be a violator. So what I'd like to hear, if your case is read, to come forward and tell us what you've done. And if you haven't done anything, why you haven't complied, and then we'll decide whether or not we should impose fines. We have 3 cases that are companion cases, cases 1, 2, and 3. I'll read those into the record. Case number 2506-115235. Location of violation is a vacant lot on Dickens Street in Fort Pierce. The property owner is Solomon Trucking Incorporated. Case number 2506-115238. Location of violation, a vacant lot on Dickens Street in Fort Pierce. The property owner again is Solomon Trucking Incorporated. And the third case that is a companion is case number 2506-115236. Location of violation is a vacant lot in Bryant Road, Fort Pierce. The property owner again is Solomon Trucking Incorporated. The investigating officer for these 3 cases is Mr. Morera. Is anybody here representing Solomon Trucking? Seeing no one, though, because it's a fine hearing, we're going to hear from Mr. Morera, who's going to tell us about the gravity of the situation and whether any steps have been taken to correct the situation.
Yes, sir. Good morning, your magistrate.
Good morning, sir.
For the record, I am resubmitting one photo dated October the 23rd, 2025. 2 are aerial photos obtained from the St. Lucie County Geographical Information System website, showing the before and after the vegetation was removed from the property. This case was brought to the January 7, 2026 Code Board hearing for Section 11.05.06, Notice of Vegetation Removal Application. Please obtain a vegetation removal permit. After the January 7, 2026, property owner was present and the case was found in default. The magistrate made the decision, the owner was not present, the case was found in default. The magistrate made the decision to present the case at the March 4, 2026 Code Board fine hearing. Vegetation permit VRP 2507-004986 was submitted July 29, 2025, and is currently in review for failure to submit any further documentation. I have remained in contact with the owner. As of March the 3rd, 2026, the property remains in violation. I'm going to read case 115238, vacant lot on Bryant. For the record, I am resubmitting one photo dated October 24, 2025. Two aerial photos obtained from the St. Lucie County Geographical Information System website showing before and after the vegetation was removed from the property. This case was brought to the January 7, 2026 Code Board hearing for Section 110506, Notice of Vegetation Removal Application. Please obtain a vegetation removal permit for the vegetation removed. At the January 7, 2026, the property owner was not present. The magistrate made the decision to present the case at the January 7 at the March 4, 2025 Code Board fine hearing. Vegetation VRP 2507-004988 was submitted July 29, 2025, and is currently reviewed for failure to submit any further documentation. I have remained in contact with the owner. As of March 3rd, 2026, the property remains in violation. I am reading case 115236, vacant lot on Bryan. For the record, I am resubmitting two photos dated October 24, 2025. Two aerial photos obtained from the St. Lucie County Geographical Information website showing before and after the vegetation was removed from the property. This case was brought to the January 7, 2026 Code Board hearing for Section 110506, Notice of Vegetation Removal Application. Please obtain a vegetation removal permit for the vegetation removed. The vegetation permit VRP 2507-004988 was submitted July 29, 2025, and is currently in review for failure to submit any further documentation. I have remained in contact with the owner, and as of March the 3rd, 2026, the property remains in violation.
Thank you, Mr. Moreira. Just for clarification on number 2, 115238, I believe you said Bryant on that one. That's Dickens Street, right? Or was
Is that
it Bryant?
115238?
Yeah, because the agenda says lot on Dickens Street.
Give me 1 second. Your
No, no
Magistrate.
problem. Take your time.
Yeah, it is. I'm sorry. It is on Dickens, sir.
It is, okay.
Yes,
Yeah,
sorry
got to get
about
that
that.
information so when we prepare the orders,
Absolutely.
we know exactly what we're doing
Yes,
so
sir.
we can do it properly. Great, thank you for that presentation. We see no one. Nothing's been followed through on this. We were hoping it would be. We'll begin at this point then for some rulings in this case. Cases. In reference to case number 2506-115235, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony, and the report of staff that the violation still exists, and having considered the gravity of the violation, the actions, if any, taken by the violator to correct the violation, and any previous violations, I make the following determination. A fine of $250 per day shall be imposed, as recommended by staff, starting December 6th, 2025, and that's $250 a day, with a maximum fine not to exceed $5,000. In reference to case number 2506-115-238, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony, and the report of staff that the violation still exists, and having considered the gravity of the violation, the actions, if any, taken by the violator to correct the violation, and any previous violations, I make the following determination. A fine of $250 per day, as recommended by staff, shall be imposed for each day the violation exists starting December 6th, 2025, with a maximum fine not to exceed $5,000. In reference to case number 2506-115-236, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony, and the report of staff that the violation still exists, and having considered the gravity of the violation, the actions, if any, taken by the violator to correct the violation, and any previous violations, I make the following determination. A fine of $250 per day, as recommended by staff, shall be imposed for each day the violation exists starting December 6th, 2025, with a maximum fine not to exceed $10,000. Let me ask you something. Why is staff recommending a maximum fine of $10,000 on this one and only $5,000 on the others?
This is a bigger lot, so their value is higher than the other two lots, so we're basing on the 10% of the value of the property, sir.
Okay, thank you. So we'll have a maximum fine not to exceed $10,000. Thank you. Next case on the agenda, 2408-113-592, location of violation 4823 Shin Road in Fort Pierce. The property owner is Butterfly Enterprises, LLC. This case has been removed by staff and will be heard on April 1st at our meeting then, 2026. Next case, 2510-115-957. Location of violation is 5211 Birch Drive in Fort Pierce. The property owner, Crystal Ramos and Megan Langmaid. Anybody here with regard to that case? I don't see anybody. The investigating officer is Josh Guevara, so we'll hear from Mr. Guevara. Good morning.
Morning, Mr. Krieger. For the record, I am resubmitting 3 photos dated July 15th, 2025. These photos were provided by the county's Water Quality Department, Mr. Jim O'Connor, and I am submitting 3 photos dated March 2nd, 2026. 5211 Birch Drive was found in violation of section 7.07.00, failed culvert pipe. A notice of violation letter was issued on October 2nd, 2025. And after receiving no compliance, a notice to appear letter was issued on December 9th, 2025, for the Code Board hearing of January 7th, 2026. At the January 7th, 2026 Code Enforcement hearing, the property was found in violation by default and given until February 6th, 2026 to comply, or a fine would be imposed. As of today's date, March 4th, 2026, the property remains in violation. I had contact with the property owner only once on December 9th, 2025. They were given the information and the phone number to Water Quality, and they haven't followed up since.
Why are you recommending a maximum fine of $20,000 on this house?
Combination of property value and the fact that they just ignored us. So Water Quality sends a letter a year in advance before we get involved, giving them ample time. They ignored their letter, then we got involved. We sent 2 letters. They called one time. They were given all the information, and nothing's been done. So staff came to that conclusion.
And
Yes,
I'd like
Ms.
to add,
Guy.
it is a serious violation. It causes many problems for the adjacent parcels. That's a factor that's added in as well.
Okay, thank you.
You're welcome.
In reference to case number 2510-115-957, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony, and the report of staff that the violation still exists, and having considered the gravity of the violation, the actions, if any, taken by the violator to correct the violation, and any previous violations, I make the following determination. A fine of $250 per day shall be imposed for each day the violation exists, starting February 7, 2026, with a maximum fine, as recommended by staff, not to exceed $20,000. Have another similar case. Case number 2510-115-956, location of violation 5209 Birch Drive in Fort Pierce. The property owners, Lydia M. and Rosando Zuniga, Life Estate. Investigating Officer, Mr. Guevara.
Yes, sir. Thank you. This property is right next to the one we just previously mentioned. For the record, I am resubmitting 2 photos dated July 15, 2025, and 2 dated January 5th, 2026. I am also submitting 3 new photos dated March 2nd, 2026. 5209 Birch Drive was found in violation of section 7.07.00, failed culvert pipe. A notice of violation letter was issued on October 2nd, 2025. And after receiving no compliance, a notice to appear letter was issued on October 29th, 2025 for the Code Board hearing of January 7th, 2026. At that January 7th, 2026 Code Enforcement hearing, the property was found in violation by default and given until February 6, 2026 to comply, or a fine would be imposed. As of today's date, March 4th, 2026, the property remains in violation, and we've had no contact with the property owner.
Again, Mr. Guevara, explain why a maximum fine of
Similar-
$20,000.
Yeah, similar to the property. This property is next to the one we just mentioned. Same issue based on property value, the fact we have no contact with the property owner, and as Supervisor Guy stated, the seriousness of this violation causing flooding in the area. The staff is recommending the amount of $20,000.
And the picture you're showing that was taken last July shows all the water in there?
Correct. These are photos taken by Water Quality when they do their inspections. They come in and they do an inspection, and they determine which culverts are failed. And at that point, they send them a letter with the information. And then if they are ignored, then we get involved. There's also a CAP program that allows the residents to get it done with assistance from the county. So there's options to resolve this. And with these 2 properties, we haven't gotten any communication at all.
In reference to case number 2510-115-956, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony, and the report of staff that the violation still exists, and having considered the gravity of the violation, the actions, if any, taken by the violator to correct the violation, and any previous violations, I make the following determination. As recommended by staff, a fine of $250 per day shall be imposed for each day the violation exists, starting February 7th, 2026, with a maximum fine not to exceed $20,000. I believe that concludes the fine hearings for this morning. So we'll move right on to the violation hearings. And during this segment, you'll have an opportunity to respond to the alleged violations. So if your name is called, please come forward. You'll be sworn in. Staff will make its presentation as to why they say you're in violation, and then you'll have an opportunity to question them or also explain why you're not in violation. Or if you are, what steps you're going to take to fix the alleged violation. Okay. No fine will be issued today, but if you're found in violation, you'll have the time to fix the violation before the fine actually imposes, and that we'll see what that date will be when we get to your case. All right, the first case was continued from last month. Location of violation 311 Southeast Solis Avenue in Port St. Lucie. The property owner was Jessica A. Rusnick, and this case has been removed by staff today for compliance efforts. I remember this case, and what kind of efforts have been taken? The officer, Josh Guevara? I know this has been removed right now for compliance efforts, but I am familiar with the case from last month. So obviously some things have happened.
Yes, sir. I've been working with Miss Rusnick. I went out there on Monday. The backyard has been cut completely.
It has?
Yes. The carport has been cleaned out of all the outside storage. Plywoods have been removed from the windows. The only thing pending is a little bit of debris in the backyard from the vegetation that was removed. She's moving it out to the curb and it's being picked up. And pressure cleaning to remove the mold and mildew. So she's done a lot, and so we thought it'd be best for to give her some time.
Absolutely.
She's been working, she's been diligent, she's been calling me, so I think everything will be resolved within the 30 days that we gave her to follow up.
That's great, because I remember from last month, you had said, you know, obviously the major concern was in the backyard.
Correct.
And that's where the complaint came from. And that was, you said if that was taken care of, we could work with you to get everything else done.
Right.
And that's what you're doing. Very good.
Yep.
Okay, thank you. Next case, 2504-114912, location of violation, 674 Nettles Boulevard in Jensen Beach. The property owner is Mario Aubin, and this was also removed for compliance efforts. The investigator in this case, Brian Alves, could you tell us what's going on? I'm curious what compliance efforts we've seen.
Well, as of recently, they've started working with an engineer and they've resubmitted for permits. There's been a lot of back and forth between the building official and their representative to try to get them in compliance. And I have not found out exactly where it stands as of recent because it just got submitted.
Okay.
And it's in review.
Okay. Or at least something's being done.
Absolutely.
And that's why okay. We will remove it at this time, and then you'll keep on top of it and then bring it back
Yes, sir.
if it's warranted. Okay. Case number 2511-116202. Location of the violation is 2701 Quail Road in Fort Pierce. The property owner is Leslie Bass. Is there anybody here? Yes. Good morning.
Good morning, Mr. Krieger.
Please state your name and your address, and the secretary will swear you in.
My name's Leslie Bass.
You'll just have to come in closer.
My name is Leslie Bass. The parcel in question is 2701 Quail Road, Fort Pierce.
And your physical address?
2708 Quail Road, Fort Pierce.
Okay. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Good morning, Ms. Bass. We'll hear from the investigating officer, Brian Alves, and then you'll have an opportunity to state your case.
Good morning, sir.
Good morning.
For the record, I am submitting 5 photos dated 11/13/2025 and 4 dated 3/2/2026. 2701 Quail Road was found in violation of Section 8.00.04 G, fences, walls, berms, and hedges. Fences or walling of vacant properties is prohibited. Please remove. Number 2, 3.01.03 J, residential single-family RS4, accessory structured fence is prohibited on a vacant parcel. Please remove the fence. The county code defines a fence as an artificial structure of material or combination of materials serving as an enclosure, barrier, or boundary, usually made of posts, boards, wire, or rails. A notice of violation letter was issued on 11/17/2025. After receiving no compliance, a notice to appear letter was issued on 12/19/2025 for the code enforcement hearing of 3/4/2026. As of 3/2/2026, the property remains in violation. I have been in contact with the property owner.
Thank you. Ms. Bass.
Good morning. First, I'm going to address you, Mr. Krieger. The parcel at issue is 185 feet by 15. It's a contiguous access lot that I use to get to a public road. It is not a residential yard, and it's not a buildable lot. Yesterday, I was informed by Ms. Brubaker that the county characterized 4 movable barricades as abandoned property under Chapter 38, Article 2, Section 3826. First, these items are not abandoned property, junk, or debris. Section 3826 applies to materials that are discarded, abandoned, or accumulated. These barricades were not discarded, and they have been no intent to abandon them. I have no intent of abandoning them. They were intentionally placed and are actively maintained as a protective barrier. They are intact, functional, and movable. Second, they do not meet the definition of a fence as an accessory structure. A fence is typically a constructed improvement affixed to the land. These barricades are not embedded, not attached to post, not fixed to the ground, and not permanently installed. The 2x4 placed between the legs is simply a stabilizing brace to prevent wind displacement. The units remain freestanding and movable. This parcel has experienced trespass, vandalism, and use by neighboring contractors as staging areas, parking lots, and interfering with my ownership property rights. I have been advised that a permanent fence is not permitted because the lot is not buildable. These temporary, movable barriers are the only reasonable method available to protect the property. They are not abandoned materials, and they are not structurally accessory improvements. Therefore, the Sidon ordinance does not apply. And I'd like to address Mr. Bryan over there on a few questions, if I could.
Absolutely.
With your pictures that you have, what evidence shows these barricades were discarded?
I never said they were discarded.
Okay. And what evidence shows intent to abandon them?
I never said they were abandoned. And I did not cite under the code that you're referring to.
Are they broken or inoperable?
They're barricades.
Did you observe them being maintained or positioned deliberately?
I did not observe them
Okay.
being
Okay.
administered at all.
Are
They
the
were there when I went
barricades,
to inspect.
as far as the fence classifications, are the barricades embedded in the ground?
No, but there are 2 posts that are cemented into the ground.
There are how many posts?
There's one on the left side of that picture, and there's one on the right with the camera on top.
Are there posts or footings installed other than that one?
I don't know.
Okay. Are they attached to each other permanently?
No. Not
Did
that I
you
saw.
cite a specific fence permit violation? I guess it's the 8 point, what you had mentioned earlier?
That is correct. 8.00.04.
Okay. If these movable barriers are not acceptable, I respectfully request guidance on what lawfully boundary demarcation methods the county recommends for non-buildable access parcels that cannot have permitted accessory fences. I have, let's see, hang on a second. I've been advised by Mr. Ben to combine the lots that I have, but that would eliminate my ability to separately develop or convey an adjacent parcel on my 2708 parcel. And I'm attempting to preserve my lawful property rights while remaining compliant with code. If these movable barriers are not acceptable, again, I respectfully request guidance on what lawfully boundary demarcation methods the county recommends for non-buildable access parcels that cannot have a permitted accessory fence. And as a note, a freestanding fence is what I'm requesting, is not necessarily an accessory for the residents, but rather a boundary improvement.
Would staff care to respond?
Good morning, Mr. Krieger. We've had numerous meetings with Mrs. Bass, and it is recommended that she has to combine the lots and then she can lawfully put a fence up with a permit, but that 185 feet by 15 feet is a vacant parcel. It is not combined with her main parcel. That's the only way she's going to be able to put a barrier up.
Let me ask you this. We're talking about, and I saw the photos here, I'm a little confused. I
This
don't
is
mind
a
admitting it.
historic neighborhood. It was built, and in the possession of a man before the college was even built. We're right adjacent to it. There's city property that is basically south of my property. That's zone city. City allows freestanding fences. In fact, they changed their code. I was advised they changed their code a couple years ago, that they allow on vacant lots a freestanding fence. I'm not enclosing this 185 by 15. Again, it's as a boundary improvement. Again, when they asked me to combine them, it creates a conundrum for me if I want to sell my lot where my home is that has another lot that has a buildable area. And then if I were to combine it, imagine the conundrum I'm going to have to do to try to uncombine it to be able to use that lot. And it's, I'm trying to work with finding someone to advise me on code and proper issues on trying to be in compliant with the county and what you're asking and the best way to address this. Sadly, the letter that I received on November 17th basically didn't have a postmark until the 18th. It was in Palm Beach on the 20th. The next week, the county's closed. It's Thanksgiving, and I was given till December 1st to try to do something with this. I called, I felt it wasn't sufficient time. Even yesterday, I didn't get notification until 4 o'clock in the afternoon about some of this being considered storage And that's why I was asking Brian, what part of this, these barriers that I have protect me, especially since there's repeating trespass, vandalism, and use by neighboring contractors and neighbors that, I feel I'm being harassed about. I have a right to be able to traverse my own property to get to a public road without interference. And there is code that says, basically, give me just a minute. If your ordinance tells me that I can obtain housing of my choice in this county without regard to your race, color, origin, sex, handicap, which I do have. And it also says your fair housing ordinance, where I'm supposed to be free of harassment and intimidation. And these are the things that I'm incurring. As far as the one post, my attempts, and I have copies of sheriff's call-out sheets where I've tried to stop the trespassing. What am I supposed to attach a sign to if I can't have one post? I can't hang this from a cloud. I feel it's being unreasonable to allow me to even put one post in. And even when I did put that there, I called 211. I made sure it was marked. But again, when I'm not given but 4 o'clock yesterday afternoon to come here to try to, talk about this issue, I don't feel prepared. I need the help of someone that I have been in contact with many people. Finally, yesterday, I found, I think, the right person that's engineering that could possibly help me negate this issue.
Mr. Krieger?
Yes,
Sir,
go
if I may. This is the second fence that was put up. The first one are in the beginning pictures. And Ms. Bass had told me, several weeks ago that she was going to remove it. It was apparently removed on 3/2/2026, and this one, the new one, was put up. And when I spoke to Ms. Bass on Monday, I informed her that I had sent the pictures up to my supervisor and then to legal, and then that's where it went out of my hands.
Okay. Legal?
Yes, Your Honor. I think it's important to just
You can sit down
Sure.
if you want. Sure.
to understand where Ms. Bass's property is. So if you're looking at this photo that we were
Could
just
you,
on.
Counsel, could you move your microphone down more?
Yes.
Okay, great.
Everybody can hear me? Okay. So I think it's important to understand where Ms. Bass's property is. So her full lot is the, can you point it out?
It's up right now.
Okay.
No, the one with the yellow
That
piece.
one.
Thank you.
Okay, so this is Ms. Bass's lot, this larger one on the bottom right-hand corner if you're looking at it as far as a quadrant. Are you following me, Your Honor?
The one,
With the arrow is her
It's
residence.
not the blue one.
yeah, okay, I got it.
Okay, so that's Ms. Bass's lot. And then the parcel, which is in violation, is 2701, and that's the yellow lot. Okay, and then the fence that is not permitted is in front of her neighbor's driveway.
It's not a driveway. I'm sorry, I don't mean to interrupt.
That's all right.
Okay, and so our issue is that it is not a permanent fence. She is allowed to combine the parcels and put up a fence, but as it is right now, as the code is currently, Ms. Bass is not allowed to put a fence, which is what this is under the definition of a fence under our code on 8.0004, which Ms. Bass has received ample notice of. And it states that fences are, and I'm just stating in pertinent part, shall require proper permits prior to construction and shall be constructed in accordance with reviewed plans and permits. So, respectfully, it is not the county's responsibility to advise Ms. Bass, even though she has received some guidance on what she could do if she really needed to put up a fence. But as it is right now, under the code, this is a fence, it's not permitted, and it needs to be removed.
And we're talking about the yellow temporary, I mean, not the yellow, the orange temporary fence? I mean, that's what we're talking about, right?
Well, so it originally
and-
was the orange fence, and now that has been removed, and the barricades.
This barricade now took the place, that I'm looking at right now, took the place of the orange fence?
That's correct.
Again, they're considering a barricade as a fence, and that's why I've asked him and tried to point out to you, they're not embedded in the ground. They're not posts or footings installed on them. They're not attached to each other permanently. They are temporary until I can get with appropriate people to help me negate, the appropriate, trying to obtain a fence, like I said, an engineer, which I was, it's unfortunate. There's so many building things going on in this county trying to get a hold of people and call back. It's not an easy thing to do.
I just want to add in there, if I can.
Sure.
Nowhere in the definition does it require that a fence be permanent at all. It's just an artificial structure of material or combination of materials that serves as an enclosure, barrier, or boundary. It does say that it's usually made of posts, boards, wires, or rails, but the main purpose is that it serves as an enclosure, barrier, or boundary, and that's what makes it a fence under definition. And no vacant property can have an accessory structure, which a fence is.
It's clearly not enclosing anything by the picture. And as far as I attempted to contact on the historic permitting of the fence that has placed there,
It's serving as a barrier. You said it yourself in your testimony that it's a barrier.
well, it's a boundary or a barrier. I'm trying to get help with this. I'm using artificial intelligence to help me, negate this process. Again, I've not ever had to be a code, so.
And sir, the complainant is the property that's shown right behind it where that.
Yeah, I was
single
going to
garage-
ask you, who complained about this?
The gentleman who,
He has no legal right to be using, again, I have 15 feet.
Oh, wait, where on this picture does the complainant reside, or?
right behind
That
it.
house.
Right behind it. That's his garage,
The house
and to the
was
left
right.
is his house.
Wait a minute, show me that back picture again. This is the neighbor's
Garage
garage.
in his driveway, and the stairwell here is the back of his house.
And you're blocking his garage.
I'm not blocking his garage. He has plenty of access in his front yard to be able to ingress and egress his property to get back there. What was put on the ground was a permissive use. And considering Mr. Bliss' grandfather gave it to his sons, who ended up giving it to him, again, I can show you pictures where he's inviting people in, like, I don't know if I can approach you to show you pictures, but I can.
You sure can.
Show you pictures.
Yes, but please show them first to staff. I want,
I can tell them.
I need, the county attorney needs to take a look at everything before I can take a look at it.
And then these were the ones from the college where I was asking Brian about putting posts on the ground. This is the college, that's what they do, that's what gave me the idea about it. This is off of Virginia. Again, they're saying it's storage, but there's,
Well, storage is not an issue today. That's not what you're cited for. Somebody may have said that to you, but that's not, they haven't filed a violation under the Storage and Debris Act.
they
Sir?
told me that yesterday.
Go ahead.
At one meeting with Miss Bass, she had, I'm going to call them logs, in her front yard, and she had asked if she could put those out there. So I took pictures of them and referred them to legal. And all I said to her was that they may possibly consider that outside storage. I said, I have to find out from legal, and that's where that came from, but it was never cited.
Yeah. Okay, thank you for that clarification. Okay, thank you. Bass, what are you showing me here?
Well, that's why I asked to try to.
Yeah, no,
Because there might be some other stuff that
No,
you're
that's all right.
probably what's on.
No, that's all right, yeah, I'm curious, yeah, like on some of these, I'm gonna, I mean, you can submit all these into evidence, I'm just,
This contractor, that's on my property, and if it interferes with my.
where's your property?
Right this way, right where I'm driving out, you go to this track, everything this way, so the center of this is what's just my property, that goes to the public roads. This is.
Go ahead.
11,
Yeah, go ahead.
Again, these are contractors on the.
I wonder if we could, so that, wait, hold on, Ms. Bass. I'd rather you be on the record, and so therefore you have to be recorded here. I wonder if they could put some of your pictures, pick out what you want. They have a machine, no, they have a machine.
It's unfortunate that I didn't have enough time because of what I was called yesterday.
Okay, maybe we'll give you some more time. Let's see, hold on. Okay, please go to Mr. Guevara here, and then go back to the podium. So we have to record your voice. Yeah, before we even begin that process, Ms. Bass, please go to the podium, please, if you may. You said you need some more time.
I do.
To talk to, and you found somebody to talk to. Is that a lawyer or?
He's an engineer, and they're also planning, certified planners.
And maybe they can do something that would satisfy the county? Is that what you're saying? You can come up with a resolution to this?
Correct. Yes, sir.
And what did they tell you as far as a time frame?
For me, and sadly, I just got in touch with him yesterday,
Yeah.
but it's emailing him and then having to coordinating a team meeting with their staff
Right.
and to discuss the issue.
Ways to resolve this?
Absolutely.
Yeah, because I'm not sure you can be just leaving barricades there, to be very honest with you.
Mr. Krieger, they're, if anything, they're movable.
They are, and
They're the only available protective option for me on this property. And for if your code is about health, safety, and well-being.
Yeah, but health, safety, and well-being also could
It
be a
doesn't-
hurricane or something blowing everything around.
Well,
You know,
some of that
I-
happens from this property.
You know, I mean, you're in a tough situation here. It's a shame that we've come to this, that we have to,
Sure
we
is.
can't resolve it with the neighbor. Have you talked with the neighbor to work this out?
Yes. Again, when a neighbor refuses to use his own property to benefit his own home and chooses to use my little 15 feet, there's an issue,
And how often is he using it?
quite frequently.
Like, if you didn't have the barricades up, is it every day?
Quite frequently. It's every month. And again, they had a gate that was there. That gate has been selectively moved. I attempted to contact, I don't remember who it was, but somebody in public records about the old fence permit, but of course that's
Yeah.
not around anymore. I do have an old picture, but again, I didn't have enough time to prepare for today.
Right. Is staff amenable to a continuance in this case? Giving her an opportunity, you said you're going to meet with somebody, or you've met with somebody who can maybe come up with something that would satisfy staff?
Sure.
I think
Mr.
the only
Alves?
problem with the continuance is, at the end of the day, the vacant lot cannot have an accessory structure. So really, the only
Right.
path forward would be to combine it to a lot that has a structure in order for the accessory structure to be there.
Right.
That's just the way that the code is written.
I
currently.
understand, yeah, and
So
I
that would
understand
really-
the code, and
Otherwise, there's really no path forward.
I
I
think,
don't
you
want
know,
to give
I-
false hope either and make
Right.
someone think that there's going to be another way around it, so to speak.
yeah, I mean, technically, I have to say, and I'm familiar with the code, you're in violation, but I want to see if we can resolve something here, you know? And I don't know exactly how we could do that. If maybe some engineers got some idea, we can't, you know, I don't mind listening to other options if somebody has a viable option. How long do you think, did the engineers say they could get with you and come up with something? You don't know, do you?
This is a busy time of year
I
for the
know it
state of
is.
Florida. I'm a sixth-generation Floridian, and this is our tourist season.
I
And
know.
you can imagine every business that you try to get help with, including us people that live here, there's delay, there's time, because there's a lot of extra people that are living down here right now. So, I mean, I need in all honesty, a couple of months, you know, that's what I'm asking, and asking for a temporary barrier, which is, you know, or whatever you want to call it, it's movable, it's not permanent. There's not a detriment for Mr. Bliss. He can still get to that, you know, detached storage area that he has from the other side of his yard, which is more consistent with the use of the property along Cortez, like his neighbors on Cortez.
And I can give guidance too as far as the temporary structures go. That is still something that's regulated under Florida Building Code that would require to be permitted, because temporary structures have to be removed within 180 days. And again, it would still, whether it's temporary or not, it's still an accessory structure on a vacant lot.
Mr. Krieger, if I may.
Oh, absolutely.
The county's position is that we've met our burden as far as proving that a fence is unpermitted and it is a barrier and it is a violation of the code. So we would object to, to additional time, respectfully. As it relates to, remedies for trespass that Ms. Bass may be seeking, potentially civilly or with an engineer, that's a separate issue. And so our position is that we've met our burden and we, nothing further.
Okay. Thank you.
Mr.
Yes.
Krieger, I'd like to also add that in October of '24, Mrs. Bass did apply for a fence permit on that property, and we denied it, and we did explain to her then, and again, we had numerous meetings with her to explain this, where nothing could be put on that lot, outside storage, anything, until it was combined.
But my ability to get to a public road is consistently and constantly being interfered with. I shouldn't have to address someone's contractor who is damaging my property. I've asked for the redress from the Sheriff's Department, who has declined my ability to press charges for trespassing. And if I can have a temporary boundary barrier in order for me to meet with Mr. Devon that I spoke with, again, I think it's not unreasonable to be able to allow me to be able to freely use the property that I own and pay a tax for. It's not the benefit of anyone else. It's for my exclusive benefit.
Mr.
Anybody
Krieger,
else?
one other thing, and you can tell from this picture too, the property that's highlighted in green owns the other however many feet of that private road.
Yeah. All right, I've heard the evidence. I'm going to rule. You said you need a couple of months. In reference to case number 2511-116202, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony, and the recommendation of staff with regard to the existence of a violation, I determine the violation in fact did occur and the alleged violator committed the violation. An order of enforcement is warranted. If the order of enforcement is not complied with by May 1st, 2026, a fine of up to $250 per day may be imposed. Please take notice that on the first Wednesday of the month after the date given for compliance at 9 a.m. or soon thereafter, as may be heard. A fine hearing will be held if the violation is not abated by the given compliance date. All right, so you have till May 1st.
Thank you very
Been
much.
found in violation. Get with the engineer, and then if you can come up with a resolution, please contact Mr. Alves, all right?
As
No
far
fine
as-
today.
Okay.
There's
As
no
far as the
fine today.
temporary, am I allowed to apply with you to have that?
That's what I was stating. So the temporary wouldn't be able to because it would still be considered an accessory structure, whether it's temporary or not. And because it's a vacant piece of property, there can't be any accessory structure, whether it's temporary or not.
Thank you. Case number 2511-116186. Excuse me. Location of the violation is a lot behind 879 Northeast Prima Vista in Port St. Lucie. The property owner is Madison Rose Holdings. Sir, please give your name and your address and be sworn in.
Michael Calandrillo, 1040 Southwest Squire Giants Lane, Palm City, Florida.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Sir, you'll have an opportunity to respond, but first we'll listen to the investigating officer, Mr. Alves.
For the record, I am submitting one photo dated 11/7/2025 and one photo dated 2/2/2026. The lot behind 879 Prima Vista was found in violation of Section 38-26, Abandoned Property, Junk, Trash, and Debris. Please remove the items such as Connex boxes from the property. A notice of violation letter was issued on 11/14/2025. After receiving no compliance, a notice to appear letter was issued on 11/15/2025 for the code enforcement hearing of 3/4/2026. As of 3/2/2026, the property remains in violation. I have been in contact with the property owner.
Thank you. Sir,
Yes. Well,
are you in violation?
First of all, this property I bought from the gas station. It's an easement, and I own the house. It's not 879, it's 872, which is attached to this Camino. I own that house, and it's attached to this lot. Now, the lot is commercial. The house is residential. So that's why I used it for storage. I own the shopping center next door, and I sold it, and the lot was the same owners as the house, so I didn't sell that. I believe the shopping center put toilet bowls and stuff there and called and complained, and I cleaned the toilet bowls up. They were doing construction right next door, so this whole thing started. I called, and I got a postponement till this month because I went to an engineer. I was told to get a pre-application with the zoning when I went down to the office. I did that. We had our meeting, and they were a little confused what I could do with this property because it's commercial, and it's not allowed to have containers there. So I said, "What can I use it for?" And they weren't sure. They really didn't know if I could attach it to the house and sell it to the church, whatever. So, but I was told that I can't use it for the containers either way. So I will remove them, but I need some time because they've been there for 10 years. I have a lot of storage in there, tools, furniture from the shopping center. And so what I'm asking for is some time to get them out of there, because I have to go through everything. So if I could have 90 days, I would appreciate that.
I see that our business navigator has approached. Does she wish to
Not
interject
necessary.
anything?
I wanted to just be present if there were any questions about the pre-application meeting. It is correct that this is an unusual piece of property. It is legally attached to the gas station. There's been a division of the property, and so it appears as though it's attached to the property behind it, but it is in fact still considered part of the parcel that the gas station is on, which is what makes it commercial general. It also means that there's no legal access to the site because it's sort of marooned in the back between these two properties. There's no way to develop it without combining it with a legitimate property with legitimate access to the site. And should it be done, it would either end up being residential or commercial general, neither of which would allow the current use. So it is correct, it's a challenging parcel.
Where exactly, I know the area very well. What gas station are we talking about there?
It's on Prima Vista. The gas station's on Prima Vista.
Right, yeah, is that the one by Prima Vista and US 1?
It's on the
Yes. Yeah.
west side of Prima Vista and US 1.
Yeah, right.
Yeah.
You
Now,
might
the other
be
That's been there
side,
familiar
forever,
with
that
the
gas
mobile
station's
vendor
been-
who sells barbecue.
Yeah, right,
there.
now I'm familiar. Yeah, that was one of the original gas stations in Port St. Lucie.
this was
It
the
was a
original
mobile-
shopping center.
Yeah, and by the shopping center, that was the original. Yeah, that's kind of a strange thing. You got to get that stuff out of there.
Yeah, I will, but it's a big job, and I'm
Yeah.
not that young that I could go zoom in there. You know, I'm going to need a little time. That's all I'm asking for. And
Who complained about this? Does anybody know?
the
of
shopping
this?
center.
The
Mr. Alves, how
complaint,
this?
it was complaint driven from the shopping center property owner.
Oh. Yeah, I can see that.
He put toilet bowls on the lot, and then he called. He was doing construction in the building right
Yeah.
next. So it's- just-
And those items were cleaned up.
They were.
I mean, you can't hardly see it because it's fenced.
Yeah.
And on the
Yeah, I
other
wouldn't
side with
see
the
it.
gas stations, they have a barbecue pit, they got wood all
Yeah, I
over
know
the
what's
place.
there. Yeah. Well, we can give you some time to get that stuff out of there. You said you need 90 days?
Yeah, well, I'm going, Easter's coming, I'm going up north to be with my family, so that's gonna kill.
But you're going to hire somebody to move all that, aren't you?
I gotta go through it, there's stuff in there for 10 years. So
You go through the stuff that's in the,
Yeah, it's
in the trailers?
in the trailers, yeah.
The county doesn't object to providing 90 days.
90 days?
The-
We'll find you in
the property
violation, give you
owner is-
90 days
He's
to
cleaned
clean
up
it
quite a
up.
bit,
All right.
yeah.
So we're going to find you in violation. You'll have 90 days. If you don't, then you're going to be fined.
I
Okay?
understand, yeah.
Okay. But no fine today, right? Let's see. All right, we'll go to.
That it?
Now, hold on a second, I have to rule
Okay.
on the case. I'm just doing some math in my head. Wasn't my strong suit, school, that's why I went into law. Okay. Well, if we went from, I'm looking at a date of June 1st. I could probably do it. That's 90 days. You get it done by June 1st?
Okay. Yep.
Okay. All right, in reference to case number 2511-116186, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony, and the recommendation of staff with regard to the existence of a violation, I determine the violation in fact did occur, and the alleged violator committed the violation. An order of enforcement is warranted if the order of enforcement is not complied with by June 1st, 2026. A fine of up to $250 per day may be imposed. A cost of $200 is being imposed as the cost for prosecuting this case. Please take notice that on the first Wednesday of the month, after the date given for compliance, at 9 a.m. or soon thereafter, as may be heard. A fine hearing will be held if the violation is not abated by the given compliance date.
Yes.
Okay?
Understand.
So you've got to June 1st to get it done.
Thank
If
you.
it's abated, then you won't have to come back. But make sure you call Mr. Alves once you got everything taken care of, so you can go out there and sign off on it. All right?
Very good. Thank you.
Good luck to you, sir. And happy Easter. All right, we have some companion cases. I'll read the two cases into the record, and then we'll hear from Mr. Alves. Case number 2509-115773. Location of violation 3229 South US Highway 1 in Fort Pierce. The property owner is ZNR Auto Sales, LLC. And case number 2509-115774. Location of violation is the vacant lot next to 3229 South US Highway 1. And the property owner is ZNR Auto Sales, LLC. Sir, state your name and your address and be sworn in.
Ziad Kasem, address of the hearing.
Your address.
About 1013 Southwest Sutter Avenue, Port St. Lucie, Florida, 34953.
Can you do me a favor and just repeat your name, please?
Ziad Kasem.
Okay, thank you. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you, sir. You've been sitting here, so you know the deal. We'll hear from the officer, and then you'll have an opportunity to respond. All right, Mr. Alves.
For the record, I am submitting 2 photos dated 12/17/2025 and 3 dated 3/2/2026. 3229 South US Highway 1 was found in violation of section 11.05.01, building and sign permits. Please obtain a permit for the fence. A notice of violation letter was issued on 9/12/2025. After receiving no compliance, a notice to appear was issued on 12/17/2025 for the code enforcement hearing of 3/4/2026. As of 3/2/2026, the property remains in violation. I have been in contact with the property owner.
All right, sir. What do you have to say for yourself this morning?
So I purchased this property like 3 years ago, and it had a fence prior to that, and I believe it was it was already there. So I don't know how long ago the prior owner had it, and then it had all these poles with chains in the front instead of that white gate. So all I did was replace it, but I was told that the person prior to me may not have gotten a permit all those years, and it was not known about. So I was just fixing up my property, but I have an issue with the mortgage holder right now anyway. So I'm just while I'm dealing with that, I'm just gonna remove the fence. I just need a little bit of time, maybe like I talked to my fence guy. He said hopefully this weekend, but I mean, I'd rather prefer to have like at least 30 days possibly to not push, the limits of it. But I'm just gonna remove it. But I thought.
Are you sure? Because that's a nice looking fence. I know you'd be in.
So the issue is I have to combine. I guess there's another parcel on that property, and I have to combine the parcels, and it's a lot easier said than done as well. So until I figure out what I'm doing with the mortgage holder, I don't want to invest too much more money into it, because it's owner finance itself. So it's just me and my prior landlord going through something, and I don't want to really invest too much more until I know a definite answer. And it's unfortunate that this issue kind of came right in the middle of it. Yeah. So but there's not much I could really do other than I thought I was okay because I was just fixing up what was already there. So it had, like I said, it had poles with chains in the very front where the white gate is, and then in the side it had a previous like metal fence, which I just replaced with a brand new black metal fence. But come to find out, I guess prior owner didn't have permits, is what I was told, and they just put up a fence or something long ago, and nobody ever found out. But that's usually my luck. So
Yeah.
And there is an open permit that's in review. The problem is that there's not a main structure on one of the parcels, and then we run into the fence on a vacant parcel problem.
yeah, we tried to apply and do all that, and that's when they
You
told
did.
us we need to combine the parcels and so on. And
I get it. So you certainly tried to work this out, and now you're in a difficult situation. I understand.
yeah, I always hit a little speed bump here and there.
Okay.
He's always been responsive, sir.
Okay, then we'll give him a little time to take the fence down. It seems like a plan.
Appreciate it.
All right. And he's been very responsive.
Yes, sir.
Okay.
I've maintained contact with him since the beginning.
Okay. Great. All right, we have two case numbers to read. And first, I'll do case number 2509-115-773. In reference to that case, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony, and the recommendation of staff with regard to the existence of a violation, I determine the violation in fact did occur, and the alleged violator committed the violation. An order of enforcement is warranted. If the order of enforcement is not complied with by May 1st, 2026, a fine of up to $250 per day may be imposed. A cost of $200 has been imposed as a cost for prosecuting this case. Please take notice that on the first Wednesday of the month, after the date given for compliance at 9 a.m. or soon thereafter, as may be heard, a fine hearing will be held if the violation is not abated by the given compliance date. I have to read one more in. In reference to case number 2509-115-774, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony, and the recommendation of staff with regard to the existence of a violation, I determine the violation in fact did occur, and the alleged violator committed the violation. An order of enforcement is warranted. If the order of enforcement is not complied with by May 1st, 2026, a fine of up to $250 per day may be imposed. Please take notice that on the first Wednesday of the month after the date given for compliance at 9 a.m. or soon thereafter, as may be heard, a fine hearing will be held if the violation is not abated by the given compliance date.
Thank you.
Good luck, sir. Case number 2512-116-387, location of violation 6642 South US Highway 1 in Port St. Lucie. The tenant was We Be Poppin', We Be Healthy, and that case has been abated. Case number 2512-116-359. Location of violation 6642 South US Highway 1 in Port St. Lucie. Property owner, St. Lucie EMI LLC, St. Lucie MEP LLC, and St. Lucie PPI LLC, and this case has been abated. Case number 2511-116201. Location of violation 1167 South Header Canal Road in Fort Pierce. The property owner is Barbara B. Batson and Christy Batson. Anybody here? Seeing no one. Case number 2504-114909. Location of violation 3055 Hammond Road, Fort Pierce. Property owner BDCC Properties LLC. This case has been abated. Good time to take a break. We'll stand in recess till 10:30. Thank you. It is 10:30, so we will reconvene. Case number 2504-114909, location of violation 3055 Hammond Road in Fort Pierce. Property owner, BDCC Properties LLC. This case has been abated. Case number 2601-116529. Location of violation 1099 West Joy Lane in Fort Pierce. The property owner is Doreen Oakley. Nobody here, we'll move on. Case number 2601-116455. Location of violation 152 Southeast Prima Vista Boulevard in Port St. Lucie. The property owner is Jareen Edwards. Hello, are you Mr. Edwards?
Yes, I am.
All right, please state your full name and your address and be sworn in.
Okay. My name is Jarin Edwards of property 152 Southeast Prima Vista Boulevard, Port St. Lucie, Florida, 34983.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, we'll hear from the investigating officer, Josh Guevara.
Thank you, Mr. Krieger. For the record, I am submitting 3 photos dated January 13th, 2026, and 3 dated March 2nd, 2026. 152 Southeast Prima Vista Boulevard was found in violation of Section 3897, overgrowth. A notice of violation letter was issued on January 13th, 2026. And after receiving no compliance, a notice to appear letter was issued on January 28th, 2026 for the code board hearing of March 4th, 2026. As of today's date, March 4th, 2026, the property remains in violation. I've had no contact with the property owner, but I see he's here today to speak to you.
Thank you, Mr. Edwards.
Yes.
Got some grass there that needs to be cut.
That was actually laid by the city, sir. Back in 2022, they came to replace a sewage tank that was in the back of my yard. So they dug up everything from the front to the back, as well as destroying the driveway. And that's the sod that they laid it back down into my property. I tried contacting or trying to get in contact with people for the past, the next 2 years after that point. Well, I wasn't able to reach anyone, and nothing was able to be done. Also, they tore down my fence and never put that up as well. So I've been dealing with it. I've been mowing it. I've been getting notices before. I tried mowing it down. Then I talked to a landscape guy, and he looked at it, and he said, that looks like weeds, not grass. Because I can show you pictures from my property when I first purchased it to what's there now. It's completely different. I was able to maintain it much better, but with that you see, it's weeds from what a lawnmower guy told me. So that grows back within like a week or two, just that high. Like I mowed it down, as you can see in the front. Everything's mowed in the front. I mowed towards the back, but just that's how it grows back every single time. But that was something the city had placed in, because they replaced the sewage tank that was in the back of my yard. They had to dig up the whole yard. They had cranes, dualies, the whole spiel. So.
Is that the city of Port St. Lucie?
Yes, sir.
Have you said you contacted them?
Yes, I spoke to somebody one time, and after that point, till they finish the job, no one contacted me from that point on. I tried reaching out to the city. There was no real direct numbers. I was always being switched around to someone else and someone else. Then at that point, it was just like left alone. So all I could do was just keep mowing or try to mow it, because I was getting notices to the home for the violations as well.
Yeah. And what's this over there, that other picture, that?
This is the side of the property. If you're facing the property to the right, this was from Monday, so there's overgrowth back there.
Right, and that's what I'm saying, sir. If you, from that point of the property all the way around to the other side, where the driveway goes into, they tore all of that up because they had to check for the gas lines. They had to check a lot of different things before they actually took up the tank.
Yeah, but how long ago was that?
That was in 2022, if I'm not mistaken.
It's 4 years ago.
Exactly, that's my point, sir. And I've been trying to contact them up until 2024. Then my father passed away, couldn't get nobody, and I just stopped, and I got depressed. And this is what I'm looking at now. I can show you the pictures how it used to look when I first purchased the property.
That's not really going to matter. What we're concerned about is how it looks now.
So my thing is this: what would the city do for me for the fact that they won't place it in? You know,
Well, that's
and it's weeds, not grass.
This is the county, though. That's not between the city, that's between you and the city. Your property is actually in the unincorporated area
What does that mean?
of the
I'm
county. You're
familiar
not,
with
it's not located in the actual city, but you have city utilities, and that's why they were in there. I know that kind of sounds confusing, but I know the area very well. So these are violations against the county code, not the city code.
So my question is this then: when they tore down my fence and everything else and tore up my sod, weren't they supposed to replace it with the same type of material or grass or even put my fence back up, which they never did?
I can't speak for the city utilities
So how do I go
department.
about
Have you
speaking to
gone?
someone?
Have you gone to the city utilities department?
All I've called was the little number that they gave me, and that was that.
I
had
would
no other-
suggest you go over to City Hall.
Okay.
You know, that's on,
Arioso?
yeah, Aroso and Port St. Lucie Boulevard, that big building there.
Okay.
Not here, there. Go in there and go to the utilities department.
Okay.
Show them the pictures, show them the evidence of how it looked before.
Okay.
And see if you can't get some kind of help there.
Yeah, 'cause they tore down my big tree and everything. Like my kids don't have a swing anymore. Like I was just left with the wrath of everything.
Yeah,
You know.
I know. But you should have got at it right away. I know one phone call, but
No,
sometimes
it was more than one phone call. By the time I was training to be a conductor for the train, so my schedule was kind of crazy, you know. But like I said, no one reached out after that point. I reached out to them. No one reached out before that point. They were just driving over my property. It was no communication whatsoever.
Yeah.
So it was just like I had to take it in a sense or leave it because they had to get it done in a sense. It was like,
Well, yeah,
you know.
was that affecting your water supply or your?
No, it was not. That was for the property in the back, the street in the back, the whole street in the back. So they had to pull up the whole tank for the back street. It had nothing to do with my
It
property.
had nothing to do with your property.
No, sir. Besides them digging up the actual land itself.
Well, they say
And
you
the
can't
fence.
fight City Hall, but I would try. I know it's late, but if that's the problem, but in the meantime, you're responsible under the county code to clean this up. It's got to
Okay.
be done.
Okay.
I mean, I hate to tell you. I mean, it's just the county didn't do this to you, and you've got an obligation to comply with the county code. When do you think you can get this all chopped down? I mean, you can get a guy in there. They got big mowers. They can get.
Yeah, but it's about money right now, and money's kind of tight for me. But if you can give me about a month, I can definitely get it done
Yeah,
for sure.
we can do that.
I appreciate that.
We can do that. Right?
Yeah, we have no objection to 30 days.
Yeah, I mean, you get some lawn services. Guys, you know, in the neighborhood, I mean, they got guys going around, I know in my neighborhood, you know.
Yeah, but
wanting
with
to
that
do work.
weeds itself, sir, with how thick and like
Oh, I know,
mossy
but-
it is,
oh, I
no
know,
one wants to
but-
touch it. Like it's looking
Well,
at it like,
They will. They got big tractor mowers can do
okay,
that. Yeah.
I'll attempt to do so again.
Yeah. Especially now with a lot of grass not growing, a lot of guys need extra work because a lot of lawns don't really need to be cut right now. You get what I'm saying?
Okay.
I'll just be very honest with you. I think you can do this and get this done.
Yeah, no doubt. In 30 days for sure, it'll definitely be done.
Get it done.
My
because
question is this,
We
though,
don't want to fine you. We don't want to fine you, but I can't.
No, not at
I
all.
can't speak for the city,
got you.
utility department. You'll have to talk with them. Yeah, that's all I can say.
Aroso on Port St. Boulevard. I got it.
Yeah,
Port St.
right.
Boulevard.
It's right there.
Okay, I will. Is there a person directly or a person name that I can possibly go to that I'd be referred to, or
I would just go to the utilities department.
just utilities and that's
department.
that?
It's separate from us, so we don't have anybody. But utilities, if it was utilities, I would say go to the utilities department in the city.
Okay.
Explain to them what happened.
Okay.
All right? Maybe there'll be somebody there with a sympathetic ear, okay?
I mean, hopefully, because they were trying to do something, but like I said, I guess the positions had switched. The person who was there was no longer working there, and
Oh, yeah,
someone
I'm
else
sure.
came in.
Well,
So then nothing happened after that point.
so
So
maybe somebody will help you out.
hopefully, we'll see.
Some good people over there.
Hopefully, we'll see.
There are some very good people over there. Okay. All right, 30 days, we can go. Well, I showed up, though. Let's see, I just want to see. default date was April 3rd. We gotta do better than that. Okay. In reference to case number 2601-116455, location of violation 152 Southeast Prima Vista Boulevard. In reference to that case, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony, and the recommendation of staff with regard to the existence of a violation, I determine that violation in fact did occur and the alleged violator committed the violation. An order of enforcement is warranted. If the order of enforcement is not complied with by April 15th, 2026, a fine of up to $250 per day may be imposed. Please take notice that on the first Wednesday of the month after the date given for compliance at 9 a.m. or soon thereafter, as may be heard, a fine hearing will be held if the violation is not abated by the given compliance date. Okay, so you got to April 15th. Get it done. Call Mr. Guevara. He can go over there, take a look at it, say, good, okay, no problem. and it's
Okay.
done.
Sounds great. Thank you.
All right, good luck to you, my friend. Case number 2601-116418. Location of violation 218 Southeast Camino Street in Port St. Lucie. The property owner, two property owners, Marilyn L. and Daniel P. Rosnowski. All right, sir, please identify yourself, name and address, and be sworn in by the secretary.
I'm Dr. Daniel Rosnowski, 218 Southeast Camino Street, Port St. Lucie, 34952.
Please raise your right hand. Do you affirm to tell the truth and nothing? Do you affirm to tell the truth, the whole truth, and nothing but the truth?
Of course.
All right. We'll first hear from the investigating officer, Mr. Guevara.
Thank you, Mr. Krieger. For the record, I am submitting 4 photos dated September 29th, 2025, taken by our Water Quality Division, and one dated March 2nd, 2026. 218 Southeast Camino Street was found in violation of Section 7.07.00, failed culvert pipe. A notice of violation letter was issued on January 5th, 2026. And a notice to appear letter was issued on January 21st, 2026 for the Code Board hearing of March 4th, 2026. As of today's date, March 4th, 2026, the property remains in violation. I've had contact with the property owner, and he's here to speak to the special magistrate. And there's also staff from Water Quality available for any questions.
Okay, very good. Sir, do you have anything to say?
Well, yeah, I got a few things to say.
All right, get it off your chest. Let's go.
Okay. My neighbor owns a construction company, and they've been pulling their big trucks into between our properties, and they've collapsed the drainage field, or the drainage ditch. The county went through in early 2024, 2025, and they cleared it all out. But since then, they keep driving their big trucks across, and they have collapsed the ditch so water can't flow. So I like the nice pictures of my house. The driveway doesn't look so good, but they want. The price I got from them initially was $6,300 to tear the whole thing apart. And then when I got the paperwork, they raised it $1,000. So I said, no way. You can't screw your neighbor. I mean, I guess you can. But the water can flow if the drainage ditch is actually open. So even the pictures show that's the wrong side. Flip the picture to the other side. Nope, not there. There.
That one.
Okay, the water can't flow because the ditch is full. And that's the, I don't want to be upset with my neighbors, but I guess I need to be. They've collapsed the drainage ditch. And now they want to, the same people want to charge me $7,300 to take care of the problem. There's a little problem with ethics in this county. Not anybody I've talked to. Everybody I've talked to has been very polite. But it's just not right. I've taken pictures just like the one shows. The one picture shows the inside of the ditch, or the culvert. And that's, water's moving, water's there. But it can't get past the area between my house and the neighbor. So I would like permission to not dig out. I don't want my whole driveway dug up for $7,300. I need to bring somebody in to unplug the culvert and someone to come along, and I guess that's the county, to dig out the ditch again. They did a fine job a year ago. And it's been just about a year ago. And then they put in sod, and that didn't help because they put in 4 inches of sod, and they just
Yeah, I
helped.
can see on this picture just taken the other day, where the culvert comes out and meets the grass, it seems to me that the grass there is blocking the culvert.
Yes, sir. Sure is. That's county property.
That it's blocking it. And yeah, how do
I
we know the culvert has
suggested-
actually failed? All right, let's see, they're saying the culvert actually failed, but I see your point too, that,
That's the culvert. That's the
Yeah.
picture of the culvert.
okay, let's hear from.
I need to
Count-
swear in.
Yes.
He needs it, okay. Please state your name.
William Cornelius?
Do you affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am. So
All
we
right,
did,
yeah, how do you know this culvert has failed?
So the county engineer overlooks all these and also determine that. When we come through and do swell maintenance, which I oversee that as well, we did do it, and an inspector follows up and looks at all that. A lot of times what happens is these pipes have holes in them, and the soils leak in from the outside and then flow into the swale, which you can see builds up on the outside of the culvert there, which starts to block it. And it does cause us to have to come back and dig them out continuously. So when that happens, they're considered failed. Sometimes you can see through the pipe, but that's not the only thing that considers it failed. Having holes inside the pipe where sand can flow in, flows down the conveyance of the ditch and builds up.
You heard what he had to say, the county representative. He says there's a buildup, because the culvert isn't working properly, there's a buildup of sediment in the culvert, and then that's what's happening, that's what's causing then the side
The swales
grass,
fill in.
yeah, for the swale to fill in.
Well, according to the paperwork, it says it's either plugged or it's collapsed. But according to the pictures, you can see why it's blocked. You can't put your foot or you can't stop a pipe and then expect it all to just be all hunky-dory.
Yeah, when was the last time the county cleaned that out?
1 year ago.
Because this is March 2nd, I'm looking at that picture, and
We clean them out when we do our swale maintenance. We clean everybody's pipe out. That's how we do the inspection for the pipe. So any soil that builds up on the outside is evidence of it coming through the pipe.
So you cleaned it out and inspected it when last?
That was sometimes last year.
So it was a year.
Yeah.
It's been a year, yes.
Sometimes it takes 6 months to a year for the sand to come through there and start filling them in.
Well, my neighbors with their construction vehicles have not helped.
Yeah.
They have plugged, I mean, if you're able to stand in my driveway and look across the drainage ditch, you can see how their side of their property, that side of the ditch has been cleaned out. Now, I've been told I have no permission from anyone to clean the ditch out myself, even though I've hired people to dig it out before. I've been told since then not to do it again. But the county has to have some responsibility here and clean that ditch out.
You can see all the sediment in this picture here that's built up there, that loose sand. That's coming from inside the culvert there. I mean, you can see the cracked driveway there. That's from the pipe starting to collapse. I mean, the concrete doesn't break down
What's
like
not
that.
to say, and I'm not an engineer, that sediment isn't coming all the way through from the adjacent property. It's going right through the culvert and
I mean, this is typical signs of it building up from that
Right.
pipe. I mean, we do hundreds of these a year. This is not an isolated incident with this property owner. We've done over a dozen of them in his neighborhood that were failed. Very similar situations.
Well, I think
has the
that's-
one next door failed?
No,
to
that's
this
brand new.
property?
The
Yeah, there's a lot of
county
people that
put
replace
that
them.
in just
A lot of
2
people are
years ago.
replacing them. Yeah.
Yes.
How old is this culvert? It's got to be 40 years old.
It's probably original to the house.
Probably the original.
Well past its
That's an older
lifetime.
neighborhood. One of the original neighborhoods in Port St. Lucie.
And on other pictures, you can see along the side of the driveway where the culvert is too, the undermining of the driveway. And a lot of times that's evidence of it coming
And
from
the crack
the
there,
driveway.
you see the driveway
Yeah.
cracking there? Yeah,
Right there.
Yeah.
yeah, I see that.
And typically, it's not coming from upstream further from somebody else's because it usually gets caught up right outside of the culvert when it hits the swale. The grasses catch all the sand. If you drive around, you can see big mounds usually in front of the culverts downstream when you have swale culverts.
That accumulation is certainly from coming out of the culvert, but it's coming out of the culvert and not going anywhere because my neighbors have stopped or have been parking on the side of the street and collapsed the ditch.
But if it's coming out of the culvert, the gentleman from the county is saying that that's evidence of the culvert failing.
Yes, sir.
Well, I understand what he's saying, but I don't agree because the halfway mark from where they've been, from my property to my neighbors, that's all been collapsed. They've plugged, and so it can't get past the plug, and it just keeps backing up.
If you replace it, your property value will go up.
If
You
I
want
re-
you want it to deteriorate further?
I had an offer on my house, and the guy said I'm $100,000 overpriced. So, yeah, my property value is not going up.
How long have you lived there?
8 years or more.
Oh, 8. You're not the original owner. Huh?
Oh, no.
And I'd like to point out too, this is one of the last houses before the outfall, so this actually blocks quite a few other residents upstream because it's, I think, the second house from the outfall right here. So there's a dozen houses before him that drain this way.
You've done 2 properties upriver, if you will.
Yes, sir.
Well, they explained to you that there is a program, right? Where he
Yes, sir.
can-
We have a CAP program that will financially help.
I would like time to just unplug the culvert. And if the county would come along and clean out the ditch, that would certainly help a lot.
Well, the accusation today is that it has failed, and I have to listen to the evidence. That's expert testimony there. If you could bring an expert witness and tell us why it didn't fail, that would be different. I hate to be that way, but I gotta weigh what I hear.
I understand your position.
Yeah.
But I don't agree that the county can just leave the drainage ditch plugged.
Well, we came in and we dug the swale out. I mean,
Yeah,
the whole,
a
it's
year
not
ago.
economical to keep coming back and blowing out the culverts. We can't do that every year. I mean, we try not to do it.
So can I have permission to dig it out myself?
I don't see no problem opening it up.
I was told I couldn't, but you're telling me I can?
I mean, we allow people, I mean, it's your responsibility and it's easement to take care of it, so, yeah.
So, okay.
I mean, but that
I'll
does,
dig
that
that
doesn't,
culvert out
I don't
myself.
think that doesn't negate the fact that the culvert's failed.
Yeah.
It's gonna be a continuous problem.
Could we, all right, if we get a little time here, let them dig it out, and then you go re-inspect and see if there's more evidence of failure.
Yeah, I mean, that's the process
Because we're
that
gonna
we,
get into the rainy season, and then you'll see. You
I mean,
should
we
see
do
pretty
issue.
quickly
Yes, sir.
whether or not the sediment is coming through again.
Well, we issue several letters for this process to actually see that kind of stuff. I mean, and when we first dug this, it did not look like this. There's a lot of buildup. I don't have the pictures with me today when we first dug it, but probably was a lot more exposed and the buildup of the dirt was not there.
I see the notice of violation was just issued in January of this year. Right?
There's additional letters that were,
Mr. Krieger, there's like the other cases during the fine hearing, there's a letter that goes out by the Water Quality Division at least a year before we even get involved. And then after that, that's when our letter goes out. So there's been 3 letters in total.
last September was the first letter we issued from Water Quality.
I got one letter, and I got one posted by my mailbox. That's 2.
So way the process works, just so you know, is that Water Quality does swale maintenance. An inspector follows through and inspects all the culverts to make sure, because there's no point in digging culverts or swales without the culverts being good. Water Quality finds these failed culverts, issues an initial letter, which we usually give about 30 days to respond. If there's no response, it's reviewed by the county engineer. If he finds it failed, then he issues a notice of violation and given an additional 30 days. Sometimes a little bit longer if people want to try to prove that it's not. If nothing's done about replacing it, then it's issued to code enforcement, which issue their notice of violation, which gives an additional 30 days. This case, it's gone even longer than that.
I just got back from Michigan about 10 days ago. I've been there since June, I think, of last year. My mother's 98 years old this year. My sister had a stroke just as I was preparing to leave for Florida. So I didn't get any of those communications from your office until I got back.
The second letter is a certified letter.
I never received a certified letter. I would have a record of that, wouldn't we?
Yeah, was it signed? I see type of service posted on the agenda too, right?
Yeah, our letter, code enforcement's notice to appear was not signed, so then per statute 162, it was posted.
Right.
That's when you saw that letter by the mailbox, at least 10 days out before the hearing. But it was posted
January 21st,
on the 21st of
2026.
January, so a month, more than a month ago.
They may have posted it, but I didn't get any communication at all from your
When can you
office
clean that out?
until I got back.
How long is it gonna take you to dig that out?
Well, if I could.
You gonna get somebody to do it, or are you gonna do it
Yes.
yourself?
No, I can barely walk. I'm not able to dig anything out myself anymore. But I'm,
You know, if you get, and I'm
a
not.
couple of
tell-
weeks at least,
Pardon?
at least a couple of weeks.
Yeah. You cut it out and you could get somebody who knows something about culverts. You can always bring them back here and they can testify as well as to the condition of the culvert.
Yep, yes.
I'll give you a little time to do that, just because the picture I see as far as the buildup there. All right, you say you need a couple of weeks to clean it out, you'll get somebody. And we can, I'll give you another hearing on this one. I'm gonna continue this case. I'm gonna continue this case, and you're gonna come back, and if you've done anything, you bring any pictures, and if you wanna bring somebody, because right now I'm leaning towards the county, because I'm getting expert testimony. You gotta present something
I
else.
understand your situation.
That's the situation I'm in.
Yes, I understand that.
But I see some things in the picture that, if you can have somebody else, we'll weigh their testimony and then we'll decide.
Well, can I get copies of these pictures?
I think we can provide you with copies of those pictures.
I can provide him with a public records request to give him all the photographs and supporting
Why
documentation.
don't you do that? And you said you need a couple of weeks.
That culvert doesn't look plugged to me.
Well, all right, we can move this a month. We can continue it to our next meeting.
Thank you.
Willing to do that. But you gotta show me more. You gotta show me more. So I hereby continue case number 2601-116418 to the code enforcement hearing on April 1st, 2026. That's when we're going to meet again. So
Yes, sir.
it's continued, so you can be back here at that time. Take any pictures, and bring anybody you'd like to speak before me, and then I'm going to make a decision, one way or the other, okay?
Yes, sir.
All right, sir. Have a good day.
I'd like a signature on someone who's going to permit me to dig out this slate.
Well, we have a public record right now that of this hearing that said you can.
I'll pull on you.
Case number 2506-115231. Location of violation 366 Notland Drive in Fort Pierce. Property owner Kevin A. Brown. Mr. Brown here.
I am.
All right, sir. Full name, address, and be sworn in.
Kevin Andrew Brown, 366 Notland Drive, Fort Pierce, Florida.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, sir, we'll hear from the investigating officer, and then you'll have an opportunity to state your case.
Thank you, Mr. Krieger. For the record, I am submitting 27 photos dated June 17th, 2025, and one dated March 2nd, 2026. 366 Mountain Drive was found in violation of Section 110501, unpermitted renovations, including kitchen, framing, insulation, ceiling, plumbing, and electrical, and Section 3.01.03J, a second dwelling in an RS4 single-family home. A notice of violation letter was issued on June 17, 2025. After receiving no compliance, a notice to appear letter was issued on January 12, 2026, for the Code Board hearing of today's date, March 4, 2026. Permit BLDR 2512-010330 was applied for on December 4, 2025, and requires resubmittal. As of today's date, March 4th, 2026, the property remains in violation. I've been in contact with property owner, Mr. Brown, and he's here today to speak to the special magistrate.
Thank you. Mr. Brown, your turn.
These pictures were taken, 4 or 5 days before I bought the property. And these violations that I'm looking at roughly represents what the house looked like. I purchased the house with these issues, but I am uncertain with the violation that is written. I haven't looked at the thing that says what I needed to correct. I'm looking at pictures, but I'm not looking at the code, I need the piece of paper that he's looking at, the violation. I don't have the particular paper that you have, that you issued me to be here today, and the code of what I'm in violation of. I came here today is because when I purchased the property, there was a lien upon the property of $10,000 from around 2018 from a previous owner. And I was here today to see if I could get that abated or moved. And the lien on the property, me purchasing the property was part of it. And as I came, starting to direct my communications with the building department, because I was new into the area, they said, go hire an engineer. Well, and then they said this would go away. Well, I went and hired an engineer, submitted plans and all the rest of the stuff. And it's basically in the permitting department, and they don't want to permit it because I basically came in and said, yeah, I can fix this stuff. But the stuff that he's showing you pictures of is not what I need that piece of paper so I can address it. What code? I am uncertain what I am in here for today about removing something. I didn't buy a house to tear it down. So I'm just curious, what am I in violation of to be here today?
Right.
I would like to see that piece of paper here in front of me so I can
Has he
address
seen the
it.
agenda? or-
Mr. Krieger,
the agenda.
the agenda is right over there. He's received a notice of violation and a notice to appear certified mail, which was signed by him with the specific violations. Also, we've been in communication with Mr. Brown since the beginning of this case.
Yeah.
The former owner of the property had a lien against the property for violations. She requested an inspection of the property to abate the lien. When we inspected, June 17th, which the photos depict, we found new violations on site. At that moment, Mr. Brown communicated his intentions to purchase the property, and we explained to him that there were violations that he would have to deal with if he purchased the property. The violations are the full renovation that was taking place in the property without permits, number one. And number two, there's a second dwelling. The carport, there's a permit from...
Before we go much further, I need that piece of paper here in front of me, why I'm here today.
Well, there's-
That would assist me in my...
It's right on the agenda.
He wants,
may be on
he
the
wants a
agenda,
copy
but
of the
I need it-
notice.
I
I don't
need
have
it
a
right
copy of
here.
the notice in front of me. He wants the notice. Which,
I want the notice that he gave me prior to me purchasing the property to say, this is what you need to fix. And one of it was cutting grass, I believe.
Yeah, and that's not here. That was abated. That was taken care of. The
Well,
two
I
pending
don't
violations.
know what it is.
What are the violations?
You got the notice. I don't have the notice.
I
in
need
front of
that piece of paper in front of me so I can proceed.
I've got,
Thank you. I appreciate it.
yeah, I'm seeing building and sign permits.
me. In 2014, Mr. Krieger, the property was cited for an unpermitted carport that was turned into a storage space.
It dictates.
And the former owner obtained a permit and permitted that carport as a storage space, not a livable space.
Right.
Then later on, we get a complaint from a tenant years later, and we find out that it's a second dwelling with a kitchen, a bathroom,
I need to hear this.
etc. And that's what the property was cited for, the second violation.
So the violations on the agenda that I'm looking at are B and C?
Correct.
The grass has been abated?
Correct.
All right, so we'll take care of that. Section 3897. So we have section 3.01.03J. You have to have a permit to remove the second dwelling. You heard Mr. Guevara talk about that carport being changed. You can't do that without a permit.
I haven't changed anything, and I have a permit history
The
of this
previous
property.
owner
Excuse
changed,
me,
the
Mr.
previous,
Guerrero?
the previous owner, and this was explained to Mr. Brown, changed the carport into a second dwelling without permits. I explained to Mr. Brown when we spoke to him, when he was about to purchase the property, that was not allowed in a residential zone, and he needed to revert it back to a carport with permits.
Okay.
I have basically the same pictures. Prior to the previous owner, that this addition has been on this property since 2010. Somebody bought an after-the-fact permit in 2014 and hired, and they forced, and this body forced them to get an engineer report to fix whatever, in 2014. This thing was addressed in 2014.
The permit for 2014 was an after-the-fact permit for turning the carport into a storage space, not a dwelling unit.
That's a carport. There is, from the permit history that I've received and the history of ownership, this room that they're talking about here has been on this property since 2010 or prior. The carport is not this. They're claiming the carport is this area here that he does not like because it has a kitchen sink in it, which is like a coffee room. But the transfer of ownership of the property, this has been on the thing, and I can see through the permit history from 2007 that at that point in time, this thing has been a 2-bedroom, 2-bath forever. And because they started doing something in 2014, they're trying, from what I can see, they're trying to build a file on this house. And I'm fine with that. But I am not in violation of doing, or the prior owner was not in violation of building this room. This room had got a permit in 2000 in
The after-the-fact permit in
the after-the-fact
2014?
permit, they forced the prior owner to get an after-the-fact permit. This thing was in existence. Can I go to where this looks at? This thing has always been here, right here. This addition has been here all the way to the back. That carport where the roof line is, where that car is parked, was what they filed for storage. It's open. It's not, and it has never been closed as far as I can see. And
So
the
where's
only
the
thing
where's the livable quote-unquote area there? As I'm looking at the picture.
I
have removed.
I went in there, the carport has been enclosed. When I went in there, and those photos show, and there was a bathroom and a kitchen in there, and there was a tenant living in there when I went in there, when I did my inspection.
When was that?
And when was that?
Prior to you owning the property, which was
I need a
explained to
date
you.
when there was a tenant there because it has been empty for 2 years prior to me buying the property.
We have a case, there's a lien on the property for that
That's
violation,
Okay.
and there was a tenant living in there.
I need dates.
The previous owner later requested an inspection, trying to remove the lien, saying it was abated, and when I inspected, I noticed the second violation, which is the renovation. But I have never had access to confirm that that second dwelling has been removed, and if it was removed, it would have had to be removed with permits.
Yeah. So is that sink and, is that still there?
From 2012, I need a date when you said you came over. That needs to be documented. When you said there was a tenant.
He's
in there.
testifying under oath. He's testifying under oath. Go
I
ahead.
am too.
And you are too. Go
I
ahead.
have pictures under oath that in Zillow, I don't have the pictures of. Can you pull up a Zillow on your phone so I don't have to approach your bench?
No.
Okay.
You
Well,
have to-
there's
you have to
pictures.
present your
There's
evidence.
pictures of this room being intact when PNC Bank foreclosed this property in 2011, prior to it being bought by 2 different other people, that this room that he wants me to tear off was intact, tiled. There was a bathroom in there. It was exactly the way it was. And what had happened, somebody had moved somebody in this one little area, a tent, making a tenant out of it. And he had a complaint that he's trying to say, well, you have to tear this off. In the permitting stack, which I pulled up the history of this, because I haven't seen exactly what he's got except this one piece of paper here saying about this other tenant. I haven't seen the complaint of the other tenant bringing this to the thing. He's wanting me to tear off a piece of a house that I purchased by saying, okay, this thing's a second dwelling. It's not a second dwelling. Show me when I have a single service mass coming into my house that this is a second dwelling. I bought a house that was a 2-bedroom, 2-bath house at a fair handshakes deal, and it had been permitted all the way back into 2012 and before what they're trying to do. So if this whole thing is on the case line of there was a tenant and they stuck him in one side of the house, this has got nothing to do with me tearing off a piece of the house that was permitted to be done. There was a carport that did have that added onto it, but that was a permit for the carport. That room has been in existence, and if it hasn't been in existence, you can show me a picture from 2012 and tell me it was not in existence.
Can I interject real quick?
I have a picture of this in existence in 2012 on Zillow, as a finished product as PNC Bank was listing it before these other two owners bought it.
Per the Florida Building Code,
Yes.
an electrical service doesn't determine a dwelling unit. A dwelling unit is a single unit providing complete independent living facilities for one or more persons, including permanent provisions for living, sleeping, eating, cooking, and sanitation. So if there's permanent provisions in there for someone to live, that is a dwelling unit.
It doesn't have 220 for a stove. It does not have, it isn't. It has a bathroom. It is a game room, effectively.
But did you, just excuse me,
So
Mr.
we-
Guevara, I want to make sure I understand, but you told him about this before he bought the property?
Correct, sir.
It is
And
not
let me, all right,
something-
look.
Yes, sir.
He told you about that.
No,
Let's-
this was
well,
done,
he-
this was
well,
done 4 days before the
So
closing.
it doesn't matter. Caveat emptor, buyer beware. That's an old legal term. Now, let me ask you this.
Yes, sir.
Building and sign permits. I mean, obviously, you need permits to do all that work in there.
No, actually, if you look up in Port St. Lucie County, what you're allowed to paint, tile, you can do all this stuff. But the room was intact in 2012 and was permitted prior to that. And what they're saying it was an addition is this open carport. This is what they're calling.
No, I'm looking at those other
I can
pictures.
look at those pictures too, but they said the carport was enclosed. This has not been enclosed. This part from here over has been part of the house since forever. The permit that they're talking about was right there. They don't like what was going on inside this part of the house because they had a tenant in there and they were doing something in that part of the house, but that part of the house has always been there. That has never been an upgrade or anything else. And the only reason that there was an after-the-fact permit picked up is because they were trying to make this case in 2014. Here we are a dozen years later, and they're still playing with it. And I want to see when the complaint was,
You
when
can do
the
a public
tenant was
records
there.
request,
That's
sir,
what
for
I
that.
want to see right here, because this is the whole part of their case. They're saying they added onto a piece of the house. They've never added onto the piece of the house. That's been sitting here since 2010. The three owners ago built this, and it's been there forever. There's nothing that has been done. There has been no new tiles. There has been no new plumbing. There's been no new electrical. At that point in time, when he's sitting here and saying that this has been a second dwelling created, it has never been a second area dwelling where it was created. It was an east wing of a house that had that was aluminum. I guess the old Florida rooms or whatever. I don't know what it was in the day, but all I know is it's a perfectly good structure today, and it's built to code according to my $6,500 architectural engineer.
Mr. Krieger?
And I deposited all this into this body's, and I've been over here, I've talked to Josh maybe 4 or 5 times, I've talked to the people over here 4 or 5 times, getting these permits, and it's sitting in limbo because Josh wants his day in court here to say that this is a second dwelling, and I'm here to tell you this is not a second dwelling, and I'm here today to see if I can get a $10,000 lien against this property removed from 2018. Because this is the only court, you, sir, are the only person that can remove that lien.
Mr. Krieger, just a point of reference, it's not sitting in limbo because Josh wants his day in court. It's sitting in limbo because Mr. Brown applied for a permit. He's not even addressing the other violation, the full renovation of the house with no permits. He applied for that permit. There's resubmittal notes, and he hasn't answered them. So that's what he needs to address.
I've answered everything that this body, from over there to over here, every single time, from the state of Georgia and in my travels to Michigan or the Keys or wherever I may be.
Mr. Krieger, 10 years ago, that case was my case. There was a second dwelling on the property from the owner. She had a tenant. You could not access the main home at that time. We had her pull that permit that he is speaking of and turn that into storage space and open the house back up again to be a full home.
I need a date.
Well, let me
With
look,
that-
all right,
I need-
excuse
I
me,
need a date
excuse me.
because that's what they're basing this on.
Excuse me. Ms. Brubaker was the original code officer here. I want to hear from her.
Yeah, so I received a complaint from a tenant at the time. I can't remember the year. I'd have to look back. It's
Okay.
been quite some time.
Let me ask you this. On the picture I'm looking at, the one that's up, where that white little fence is, or whatever the heck that is that's the area we're talking about?
Correct.
Okay. I'm looking at the roof. I'm looking at the roof. It seems like there's a division between the house and there's like a second roof there.
It's a
that
stoop.
comes on, well, excuse me,
It's a
sir.
smoking-
Excuse me, sir. I'm giving you all the time to speak, but you have to wait.
Yes, sir.
It looks like that was added on or could have been part of an original carport. And then somebody went all the way across. Is that what that is? That roof wasn't part of the original roof of the house, right?
No, the permit was they took the carport and turned it into storage space. Then they constructed a new carport with 2 windows, and that was in 2014.
And that's the new carport we're looking at? I mean, were the cars inside there? That's the carport?
I believe so, but there was a different carport at the time that did get closed in. And that's what was the apartment.
And where you see where the fence is, Mr. Krieger, behind the fence is the door, which was the entrance to that efficiency, which was enclosed or separated from the main house on the other side of the house. There were 2 doors. There was one
Yeah.
on the outside and one inside the house that separated that unit completely from the main house.
Let's, I don't want to belabor that point. I want to go on with the full house renovation. They're saying you need permits, and you've submitted for permits, but there's a bunch of comments that haven't been addressed?
This is the main comment right here, is the reason we're here today.
I don't want to, answer my question.
Yes, sir.
Did you applied for permits for the major renovations, and you've gotten comments back. Have you addressed those comments?
I've addressed every comment that I can address.
There still requires resubmittal from ERD, which was submitted on February 3rd, and from zoning, which was submitted on February 3rd, and he has not replied to those resubmittal requirements.
What is it? I've been in here and I sat across the table from somebody inside the zoning, and we talked about this. And they didn't like the way my driveway was listed. And I told them, well, I'll go back downstairs or whatever. And I removed the driveway because I wanted to remove everything that's hindering me from being able to work on this house. So I removed the driveway permit part of this application because I wanted to come here and fluff the whole thing where I could have a driveway and not be over there sitting in that yard as you're looking. I mean, it needs some concrete in the yard, and that's one of the main things I wanted to do is give it some more curb appeal. And when I purchased the house, it was not a second dwelling, and I believe the second dwelling is the whole hiccup, and that's why I'm in this court today is because of the second dwelling. And it's not a second dwelling, and more or less they're asking me to rip off a third of the house. Is what I'm guessing is they're saying you're not complying, you're not pulling a permit to rip this off. I did not purchase the house with intent to tear the house down because they said the carport was there. And the history that I have pulled up is from the people who writes out all these the ownerships and stuff. They gave me an outline of the house. They're the ones that had all that information, and this was prior to 2010. So there may have been an issue. Was somebody renting a room out a dozen years ago? But that has nothing to do with it being a secondary dwelling.
Mr. Guevara said he told you.
Yes, sir.
Before you bought the house.
Yes, sir.
That somebody was living there.
Yes, sir.
Nobody was. Nobody was living there.
He told you that. Why?
There was nobody living in the house, and that part
Why'd
never
you go
came
ahead
up
and
that
buy
that
it
was
with-
a second dwelling.
With these issues hanging. You know, caveat emptor, buyer beware.
There's not an issue.
Look, as far as the lien is concerned of $10,000, you can always come back and ask for that to be removed.
It was supposed to be able to be removed.
Once you are in compliance, once you've done what you're supposed to do, and you still haven't addressed to me why you haven't taken care of all the permits for that major renovation going inside.
I don't
the
have
house.
any major renovation going on. They
Well, the
will not
pictures
issue a permit.
Pictures look to me like there's a lot of stuff going on in there.
Can we pull up a Zillow report?
These photos here, Mr. Krieger, this is not the second dwelling. This is the main house.
Yeah.
And they were doing a renovation without permits. He hasn't even addressed that.
That was like
That's
that.
what I want to address.
This man walked in the house 4 days before I got there.
And you were told and you bought it that way.
You buy it that way. I'm
You were
sorry.
told,
You
Mr.
buy
Dunn,
it
you
that
bought
way.
it that way.
You bought it that way. You're stuck with it that way. That's just the way it is. If you sat through enough of these hearings.
I'm here about removing a second dwelling. As far as the
Well,
renovation.
you've been cited for other things that I want to talk about.
Where I'm at today is B, the number one I'm here for, according to this piece of paper. Number B, section residential single-family dwelling. A second dwelling is not allowed in the RS4 zone property. Please obtain permits to remove the second dwelling. Please obtain a permit to remove the second dwelling. And he repeated it twice in this thing right here.
Okay, that's fine. But then
This
we have
is
C.
what I'm here to address
Well,
today.
all right, you've addressed it. I've heard your position. I've
Well,
heard
it's not-
county's
it's just not a
position as
posi-
well.
it's just not a
Let's
position.
hear about the permits on the main.
I've
dwelling.
got them submitted. They won't give me a permit to do renovations because they want to deal with Section B. They want part of the house ripped off, and part of the house was there in 2012. I do not have the pictures to show you from a Zillow.
If an area is being
There
used
it is,
as a
2012. Keep coming. There's the kitchen, 2012. It's there. This is it. Beautiful. There you go. There's 2012. It was there. Let's go down and do some more. Oh, there's another place right there. There's that bedroom. Stop. There's where the drywall is that you just looked, where the door was hanging off the hinges. This was the room in 2012. The only difference is that the door was off the hinges.
Mr. Krieger, none of the comments have anything to do with the dwelling unit.
Go to the next one. Here's the bathroom. Here's the second. There's another second bathroom over there. Not there. That's it. That's not it. That's on the west side. Go back down.
Is that the second dwelling?
That's not what they're. That's not what they're doing. This is the laundry room.
These are from.
Let's go back down. Let's walk through this house as we're going. That's the west side. Hey, stop. Here's 2012. Here is where they say in 2012, this is the dwelling right there. You see that window? That's where the bathroom is. That's the shower. See that? That's in 2012. Prior to any tenant being in the house, and there was a permit pulled for that. There's the kitchen in 2012. It was not a kitchen. Go back, if you don't mind. There's it, right behind that shower. There's the shower wall. This was intact in 2012 when PNC Bank owned this house.
I don't care what PNC.
Right there.
What was the? All right, hold on. All right, hold on, sir.
This
Go
is
back.
what he- this is
Go
what
over here.
he's-
All right, look. Let me. You know what? Let me go back on a couple of those pictures. Where is the
Right there.
the
Go back,
second
go back
dwelling?
one. Go back
The
one.
second dwelling. Show me pictures of the
Mr.
second
Krieger,
dwelling.
and that, go back to
No,
that
no,
picture.
go back.
No, all right,
In that
sir.
picture
Let
right there,
Ms. Brubaker
that
talk.
was a carport right there that got closed in. That was the carport, and that is the permit I was talking about in 2014. It was
No, it's not.
to create this. Yes, it was. They enclosed the carport, and then they created it as a storage room and added another carport. These are 2012 pictures. We're going back 14 years.
That's not the carport.
That was the original carport, sir.
That's not the original carport. The original carport's where the car
And
is.
Mr. Krieger,
That's what was pulled.
like the building official
That
said,
was the newly constructed carport where the car is currently. I'm looking at the plans.
and like the building official said, none of the comments for the house renovation have anything to do with the second dwelling.
The comments
I'm
that
here
are
about
current.
second dwelling.
Well, that's fine. You're here
Let's-
for that, but
let's-
we're
let's
also
go-
here.
let's- Your Honor,
All right.
Your Honor, can you please show the picture? Go back and let me tell you where to stop. That's the second dwelling that they're calling. There, right there. This is what they're calling the second dwelling. Okay?
Kind of looks like.
It looks like a piece of the house.
It goes into the main house.
It's connected to the house, just like the other side is connected to the house. And it has been since they built the house.
It has its own front door, and then it has a secondary door leading to the main house, so it is a secondary.
Yeah, that's the door right there, right?
Right
And the
here.
window, when you look at.
There's a window.
All right,
This is
all right,
part-
all right. I hate to, you got to settle down. Sit down. All right, look, Ms. Brubaker,
Yes, sir.
because since you were there originally, you were showing me the outside where the carport was, where you could see the window. Right? Go back to the outside view. It was the old one, no. There, okay. There's the, I can see a window right here, right? The newer window?
Yes.
That's part of the carport, right?
No, that's
No,
what
it
they're
looks
calling
like-
the second dwelling.
Yeah, which would be part of the original carport. I can see the roof. I can see that, and I can see that window. Now, when you go to the inside pictures, Ms. Brubaker, can you show me where that window?
That's in the bathroom, I believe.
Yeah.
That's the shower. And there's a timestamp at the bottom of each of these things, and it tells you exactly the existence. and
Oh, there's
shape
that
this
window, okay,
place
that,
was in.
all right, excuse me, sir, I'm talking. That's the window, right, Ms. Brubaker? You're
Correct.
showing me right there with the shower?
Correct.
Okay, and that was the window we just saw on the outside, that looked like an attachment to the main dwelling.
Right, the older owner there, Mrs. Chagani, I believe it was, she enclosed that. I don't know what year she enclosed it. It could have been enclosed in 2000, but we
She
got
did
a
not own the
complaint.
property until
Sir,
2014.
can you please be quiet
Well,
and let
then it could
staff
have been
speak?
the owner prior.
Stop.
And somebody did enclose it. We received a complaint from a tenant at the time complaining. We went in, and that's when we realized it was a second unit. And then Mrs. Chagani did get the after-the-fact permit to convert it to storage space and remove the tenant. We then went back
Okay.
into the property, and it was made as a whole house again, and the tenant was gone.
Okay.
So we closed that case.
Okay, I understand. But then Mr. Guevara said he went out there and there was a tenant.
Correct. So after that, we received, years later, another complaint, and she had reverted back to having a tenant in the second dwelling. We went in there, we documented, it was cited. A lien was put against the property for lack of compliance. Ms. Nagami called stating that it was in compliance now, and at that time, Mr. Brown communicated his intentions to purchase the property.
Okay.
I inspected, saw the new violation, and saw that the
Okay,
old
I've heard
violation
enough.
was still there, and explained to Mr. Brown what the situation was.
Okay, I've heard enough. I've heard enough. Let me ask you this. So you bought a foreclosed house?
No.
Did you
need to listen to me,
no.
please. Please.
I've let you talk for the last half hour.
That's
I'm
why
a
I'm
pretty
here.
mild-mannered guy, but I can also shout. Let me ask you, was this a foreclosed home? No. No? You're saying PNC Bank, PNC Bank, what
In
are we talking about?
2010, I'm establishing when this room was built. They're establishing the second dwelling on a complaint.
Okay.
That they haven't given me.
All
a
right, I
date
just
of this
asked whether it was
compliance.
a foreclosed house, but that's really not relevant anyway. What's relevant is what we have before us, and I've seen the evidence. All right, sir? And I'm
These are timestamps.
all right,
This-
that's
this-
right, and I've seen the evidence, so I'm prepared to rule. Sorry, buyer beware, caveat emptor is the term. In reference to case number 2506-115-231, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony, and the recommendation of staff with regard to the existence of a violation, I determine the violation in fact did occur, and the alleged violator committed the violation. An order of enforcement is warranted if the order of enforcement is not complied with by May 1st, 2026, a fine of up to $250 per day may be imposed. A cost of $200 has been imposed as the cost for prosecuting this case. Please take notice that on the first Wednesday of the month, after the date given for compliance at 9 a.m. or soon thereafter, as may be heard, a fine hearing will be held if the violation is not abated by the given compliance date. Thank you, sir. Let's move on. Case number 2512-116-345. Location of violation 3176 South 25th Street in Fort Pierce. The property owner is AG and JM LLC. Ms. Moyes, good morning. I think it's still morning. Okay.
Can you
And we
step
have a
up?
gentleman here. Please state your name, address, and be sworn in.
My name is Segundo Maldonado.
You can move the microphone.
5141 Northwest Dome Road, Fort Pierce.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth?
Aye.
All right, sir, we'll hear from Ms. Moyes, and then you can state your case.
For the record, I am submitting one photo dated December 13, 2025, two photos dated February 12, 2026, one photo dated March 3, 2026, and a copy of the property appraiser's record card photo taken on September 9, 2021, which shows what the home originally looked like. During my first inspection, I found the property located at 3176 South 25th Street in violation for Section 11.05.01 Building and Sign Permits to please obtain a permit for the new garage doors, Section 11.05.01 Building and Sign Permits to please obtain a permit for the front door, Section 11.05.01 Building and Sign Permits to please obtain a permit for the renovations done to the exterior of the structure to include the enclosure work done by the front door area. A notice of violation was issued on December 16, 2025, with a compliance date of December 30th, 2025. After getting no compliance, a notice to appear was issued on January 7, 2026, for the March 4, 2026 special magistrate meeting. In addition, a notice to appear was issued and posted on the property on February 12, 2026 for the March 4, 2026 special magistrate meeting. Permit number BLDR-2602-010785 was filed on February 24, 2026. I'm sorry, February 24, 2026. On February 25, 2026, the permit was denied due to the incorrect filing of the permit. So therefore, the permitting department did notify the owners and a new permit was filed for. Permit number BLDR-2602-010803 was filed on February 27, 2026 for the entry door. Permit number BLDR-2602-010802 was filed for the garage doors on February 27, 2026. Both permits are still in review. I have had contact with the owners, and as of March 4, 2026, the property remains in violation.
So you said two permits have been applied for,
Yes, the two permits were applied
and
for.
that'll cover all the three violations, the new garage doors, the front door, and the enclosure work done in the front door area?
Well, I do know the two permits will cover the garage door. One will cover the garage door, one will cover the front door. I'm not sure about the work that was done around the front door area. So that would have to be discussed. He would have to discuss that with the permitting department.
Right. Permitting probably hasn't had a chance really to review everything, or
Right.
has it?
There was a review performed, but I don't remember seeing a permit in there specifically for that area in the front. It was just for the new garage door and then the front door.
So he has to really apply for another permit for the work done around the area?
Correct.
Do you understand that, sir? What they're saying? You applied for two permits, but I think they're saying you got to get three.
The building department told me only two for the garage doors and for the entry door. I went to the building department, they told me I need two.
But you did more work around the exterior of the house, around the door, the front door.
Usually I bought the house the way it is.
Yeah, well, it's not the way. We don't want to go there again. You know,
No,
you're stuck with whatever you buy. You understand that?
I understand
That's
that.
what I was trying to explain to the other gentleman, that you're stuck with whatever you buy. You know, it's. I don't care what anybody did before. You took it. You know, and then you're kind of stuck with it. So you got to be careful when you buy stuff. you know?
So the second permit's going to address, if somebody can go back to the original picture that shows the French doors. See how there's a double door there?
When I bought it, the house was only single door.
All right, we're not worried about how you bought, what you bought, but there was 2 doors there. So now you have to permit that section that was closed off and walled off. You have the permit for the front door. When a replacement door is applied for, all we're looking at is an NOA saying, yeah, it meets the wind pressures. But if you don't tell us that it was switched from a French door to a single door, we don't know that there's work to the wall. So that has to be permitted separate as well, showing that that other half of the wall was closed off and that a single door was put there. Does that
What
make
kind
sense?
of permit I have to apply to correct that?
It'll be a residential alteration.
Okay.
You can do that.
Yeah, I can do it now. Just to
Sure.
give me a few
Because
time.
you know, obviously, this looks good. I mean, considering what that home looked like before, this is wonderful.
Oh, yeah.
I mean, you do good work, but you got to get the permits.
I'm gonna sort the general
And they're
contractor
saying,
to.
yeah, you know, it was a French door, and now that it's just one door, you had
Yes.
to make some changes. I get that, and I'm not a contractor. So that was an little extra work that has to be done. So you got to apply for one more permit, and then they're going to review everything, right? Inspect it. Mr. Jernigan? So Mr. Jernigan, he applies for the third permit, and then you're going to look at them all, and then you're going to have somebody inspect everything? Is that what the deal is?
Correct.
So we're almost there,
Yes.
right?
We're on the right path.
We're on the right path. I mean, looking at what's been done, looks really good. I don't know why you didn't get the permits in the beginning.
The previous owner,
Yeah.
they replace everything. I just do a power wash and painting.
Oh,
Yeah, I was going to say, I think he got the entire house, that the work was already done like
oh,
that.
okay, I misunderstood.
Yeah.
Okay, well, yeah, so then you got to do it if they did
If
it
you
without
go
the
ahead and give me a
permits.
call later today, I can sit down with you and we can go over what's necessary for the permitting.
Sure, no
Okay.
problem. Okay.
Okay, that's good, I get that. So this shouldn't take too long, I don't know. I don't know if we shouldn't continue this one. I don't know what staff thinks on that. Give them a chance to,
I have no objections. It seems like he's on the right path forward.
yeah,
Yeah, the county doesn't object to granting a continuance,
maybe a couple months.
90 days.
90 days?
Yeah.
90 days? We should probably, all right, we're gonna continue your case for 90 days.
Okay.
That's gonna give you a chance to get that third permit in there, and then Mr. Jernigan and that, you're gonna take care of everything, you're gonna get an inspector. Ms. Moyes is gonna go out there too, and hopefully everything will be taken care of and you won't see me again.
Okay, thanks.
All right?
Okay.
All right, let's, what would be the date for our meeting to continue? 90 days. Is that June? It's June. Yeah, June 3rd, we could do it, all right. I hereby move to continue, not move, but I hereby continue. Case number 2512116-345 to our hearing, special magistrate hearing on June 3rd, 2026. Okay. Good luck, sir. You're done.
Okay, thank you.
Case number 2504-114865. Location of violation, 4100 Metzger Road in Fort Pierce. Property owner is Michael E. Filaramo, trustee, and Elisa C. Filaramo, trustee. Anybody here? Probably. We'll move on. Case 2512-116344. Location of violation, 1702 Wyoming Avenue, Fort Pierce. The property owner is Yunel Gonzalez. Anybody here? Don't see anybody, we'll move on. Case number 2509-115901. Location of violation, 1901 South 33rd Street in Fort Pierce. Property owner, Alex Hensley. All right. All right. State your name and address and be sworn in.
My name is Alexander Hensley. My address is 2108 South 33rd Street, Fort Pierce, Florida.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. Mr. Hensley, we'll hear from Paula Guy, the investigating officer, first, and then you can speak.
Thank you. For the record, I'm submitting 9 photos and 2 audio videos taken by myself. The citizen complaint received for persons living in an RV on a vacant lot located at 1901 South 33rd Street was found in violation of Section 3.01.03, subsection L, RM5. Outside storage is permitted without a primary structure on the vacant parcel. A notice of violation letter was issued on September 26, 2025. After receiving no compliance, a notice to appear letter was issued on December 3, 2025 for the Code Board hearing of today, March 4, 2026. The service for the notice to appear was completed via certified mail on December 6, 2025. There was a previous case, 115281, that was assigned to Officer Bess, and it was scheduled for a November 2025 hearing. The case had to be closed out due to errors on violations issued, and this new case was reopened and recited correctly. The owner has been aware of the violations since July 17, 2025, and has been in contact with County Code Enforcement. I was first able to establish communication with the property owner on October 20th, 2025, and have spoken with him on numerous occasions in regards to the corrections required for this vacant parcel. The property owner purchased this property back in 2019, and he's had multiple code violations in previous years where he actually had to demolish the home that was previously on the parcel. As of March 4, 2023, the property does remain in violation. I have observed a few things removed, but there is still items there, and apparently somebody is residing in the camper on site as a generator runs. Every time I'm there, you can hear it.
All right, Mr. Hensley, you heard the officer speaking with regard to having stuff there and somebody living there. You can't do that. What's going on?
I had a truck to be able to move everything. Back in October, the truck has been totaled, so getting help to move everything has been like a problem for me. I mean, that's all I really have to say about that. It's you have to have a certain truck to move that camper that's there. So.
Right. So what do you plan to do? You can't stay there forever. I mean, you're in violation of the law.
I've been in the process of moving everything. I mean, I have to pay somebody to use their truck or whatever. I mean,
Are you living in that?
No, I'm not.
Who's living there? Okay. Can't do that.
Yeah, I know.
You got to move it. I mean, my hands are tied. I mean, the law is the law. The code is the code. Give you a little time, but it seems like you've had a lot of time.
Yes, I've had a lot of time.
I mean, this goes back to September, correct?
For my case, yes.
Notice a violation there, but there was a case before that and it was refiled, right?
Yes, sir. 3 months.
So 3 months before that.
Yeah, it was in, I believe, June, early July.
Wow, that's a long time. They've been pretty lenient with you. I mean, give me an estimate when you can move, when you could get this done.
If it was up to me, if I had a truck, it'd be done tomorrow. But
Yeah, but how about hiring somebody to do it?
yeah, I mean,
Or renting a truck to do it?
Yeah, that's no problem. I can do that.
Yeah, I mean, you can rent something and move it.
I don't picture more than 30 days.
You don't? Okay.
It'd be done tomorrow if I had a truck,
If
honestly.
you had the truck, right. So you could move that, and what else is there? We have So what are the things that gotta get done? We gotta get the trailer out of there. Nobody can be living there. And
There's
then what
no-
are the other miscellaneous items again?
There's
What-
no items that are allowed to be stored on the property.
Anything.
So all items
Everything
on
that's
the
there.
parcel has got to be removed.
And what's there? Just kind of explain it again to me. What else do we got there? I can't see everything with the pictures because we got a lot of brush there, you know? Like that, is that a sign? I mean, it's a nice drawing and everything. Is that being stored there too?
Yes, there's 2 of them.
Yes, it's a mobile billboard.
Mobile billboards, they can't be there. That shouldn't be hard to move. What else? You got mobile billboards? Anything else, Ms. Guy, that you can?
There's commercial equipment there. There was 2 campers at one time that was over on the southwest corner, which has been removed. The main RV is still there with the generator and different types of commercial equipment that I can see visible from public access.
Yeah.
So I can't give you the specific details of every
Right.
item that's stored due to.
Right, I get that.
I am getting a lot of citizens, calling, complaining because of the activity with the generator and things of that
Yeah.
nature. And it
Yeah,
is
it's gotta
directly
go.
across the street from the elementary school.
It is?
Mm-hmm.
What elementary school is it?
It's the one on Delaware in 33rd Street.
Okay.
I'm not sure of the name of it. It's a public school.
Okay, give you a little time, but this has got to be done, okay? Got to get a truck and you got to get everything out of there. All right, sir. Anything else, staff? Anything else?
No.
Mr. Hensley, anything else? I know you
No.
seem like a nice mellow guy, and I like that. Appreciate that. Okay. In reference to case number 2509-115901. In reference to that case, I, as special magistrate, make the following determination. After hearing the facts in this case, the testimony and the recommendation of staff with regard to the existence of a violation, I determine that the violation in fact did occur and the alleged violator committed the violation. An order of enforcement is warranted. If the order of enforcement is not complied with by May 15th, 2026, a fine of up to $250 per day may be imposed. Please take notice that on the first Wednesday of the month after the date given for compliance at 9 a.m. or soon thereafter, as may be heard, a fine hearing will be held if the violation is not abated by the given compliance date. All right, sir. May 15th.
All right. Thank you.
Okay. And you have to call Miss Guy in the department as soon as you got everything out of there so she can take a look or send somebody there
All right.
to clear it, all right? Because I don't want to fine you, all right?
All right. Thank you.
Okay. We have an addendum for the violation hearings. Case number 2602, 116631, location of violation 8021 Okeechobee Road in Fort Pierce. The property owner is Sakaza Real Estate LLC. Is somebody here?
Nope.
Representing the alleged violator, okay? All right, let's deal with those who haven't shown up. I believe that's what we have to do. We get default orders. Just give me a second. There are only a few. Case number 2511-116201. Location of violation 1167 South Header Canal Road in Fort Pierce. Property owner Barbara C. Batson, Christy Batson. Case number 2601-116529. Location of violation 1099 West Joy Lane, Fort Pierce, Florida. Property owner Doreen Oakley. Case number 2504-114865. Location of violation 4100 Metzger Road in Fort Pierce. Property owner Michael A. Filorama Trust and Elsia C. Filorama Trustee. Case number 2512-116344. Location of violation 1702 Wyoming Avenue in Fort Pierce. Property owner Yunel Gonzalez. I believe those are all the people who have not shown up. So have the halls been sounded?
The halls
you.
have been sounded. Thank you.
In reference to the cases that I just read into the record, I, as special magistrate, enter an order finding these alleged violators are in default, as they did not appear to protest the violations against them, and I adopt the recommendations of staff as set forth on the agenda. Okay. No rehearings, no repeat violations today, nothing to refer to the Board of County Commissioners, no fine reduction hearings, and then we have no other business, but we have staff business, and that's for the approval of the 2026, I should say, lien amnesty program, which would run from April 1st, 2026 to July 1st, 2026. Ms. Guy, tell us about the program.
Thank you. I'd like to request a motion for approval of the St. Lucie County Code Enforcement Amnesty Lien Program for the year of 2026. This lien amnesty program has been an incentive to property owners with outstanding code enforcement liens. The program aims to encourage property owners to bring their properties into compliance and the county codes and ordinances. This results in a quick reduction of their outstanding liens. The duration I'm proposing is April 1st through July 21st, 2026. The terms of the program...
July 31st, right?
July 31st, 2026, yes.
Okay.
In the terms of the program, it's available to all residential and commercial property owners with outstanding code enforcement liens. They would be eligible for a 90% reduction of lien if the property is brought into 100% compliance. The entire property must be in compliance with all county codes and ordinances. The property owner shall not have any active code enforcement violations for any other properties owned in the unincorporated areas of St. Lucie County. The properties will be inspected by a code enforcement officer to confirm that there is no code violations that are open or active. Upon approved inspections, the reduced lien will go down to 10% of the original lien, and any collection fees must be paid within 30 days, or the fine will resort back to the original fine amount. The county does provide a bulk mailing that goes out to residents, informing them of all the details and requirements of the programs. We research any outstanding liens and send them mailings to the residents' address that we have on file. We also do a press release that goes out to the public for education and awareness. We have an active, on our website, very informative and easy, user-friendly for participants to research and find that information. So in addition, I've also had inquiries of surrounding municipalities over the last 12 months asking about our program, wanting to know the details and how we do it so they can offer that to their citizens as well. So it is becoming more popular, and it's something that assists our citizens that are here, in our county.
And it's been fairly successful. You've provided a chart with regard to how many funds have been collected.
The program's been in place since 2017.
Correct. And last year, there were 29 participants, and
That is correct.
collected $19,495.
That is correct. And that was 29 properties that were brought into compliance that wouldn't have been otherwise.
That's right. That's right. Okay. Anything else?
No, I think it's a great program. A lot of people are able to take advantage of it that would not be able to pay off that fine otherwise.
All right, I hereby approve the lien amnesty program for 2026. Get the letters out.
Thank you so much.
I believe that's all we have. Anybody else have anything else for today's meeting? All right, well then we will adjourn, and the official time is 12:02. Thank you. Have a good day.
Thank you.